Confirmation for tomorrow.
Let us see.
Serial number 20, my lord. I am for the petitioner. A week's time may be granted. In that, my lord, in writ petition 20.2, I filed an application. Petition number 1 died. I filed an application to bringing them.
It has not come.
Yes, my lord. It was.
Yes, list after all this.
Please.
Serial number 23, my lords. I'm appearing for appearance after vacation, my lords.
Poultry farm.
Yes.
Yes. There are IAs for setting aside abatement, sir.
It's all, last hearing date, it's been allowed, my lords.
Yes, Mr.
Much obliged.
My lords, I'm appearing for the appellant in 42. I have instructions to file NOC wakalat in this matter.
My lords, we have an objection to the adjournment being sought. In fact, it had come to our knowledge that NOC was given almost 1.5 months ago. We have urgency in the matter. In fact,
I
we
have
filed.
received instructions to file NOC wakalat now.
Yes, we'll list it immediately after holidays.
My lords, there's an interim order which may be extended.
Till then. Till the next date.
My lords, can a fixed date be given? 21st of October if possible.
21st.
Obliged.
Stateful, my lord.
Nice.
In 49, my lord, I appear for the respondent number 3. My lord,
Date on Friday, not listed. Direction issued by our lot, find out. That whole 31 without posting. They are seeking only tomorrow.
tomorrow, my lord, today senior is not in station, my lord.
Friday.
Tomorrow, whether it will be possible, we don't know. Yes, anyway. Please. Which is the item?
Serial number 71.
71 is in the orders.
My
list.
lordship, if I withdrawing
Pro-
the case, my lordship.
Okay.
Court fee may be refunded, my lordship.
It's usual orders. Withdrawal. Refund of court fee under proper identification. Memo filed for withdrawal. Record it and 71.
Yes, my lordship. Much obliged.
Page 48, 81 and 82, 49, 84.
They pay for the appellant.
In 83.
Right, act of-
Yes. Please inform the other side. Please inform the other side that it has been adjourned.
State only.
State.
Page 55 and 86. Page 47, page 55, 88 to 90. 56, 91 to 93. 57, 94 to 97. Page 58, 98 to 101. Page 55, 102. Page 56, 103 and 104. This 2. Number 1.
Yes.
My lords, it's regarding translation, my lords, English translation,
Item, this is
second list.
just a moment, Translation usual orders. List immediately after orders.
Please, my lords.
All the matters in 1 to 41, in cases where there are translations, the usual orders, relevant translations will be provided. All the others, 2 weeks time granted to comply with the office objections, list after orders.
Great.
That applies to the entire list. We can't take one by one.
One. Number one.
Appellant in this.
Appear for the appellant in this case, my lords.
Yes, the judgment you had relied on is only in respect of section 9 and the applicability of an appeal under section 37. It does not refer to the present situation. 13 is clear. Therefore, there is no question of an order of non-grant of ex parte interim injunction being appealable under section 13. The as also grant of local commission is also not, non-grant of local commission is also not an order which is appealable. The appeal is fails on maintainability. Found to be non-maintainable, dismissed as such.
May I reserve liberty to file a writ petition, my lords?
Whatever, all contentions are left open. We have only said that the appeal is not maintainable. The judgment is absolutely not applicable to the facts of the case.
Please, greatly obliged.
Sanction and plan access to landowners,
Please,
alternate remedy.
Please, my lord.
Alternate remedy
Is
is
sought for, my lord, civil dispute, my lord, regarding the easementary right, my lord.
The question is only with regard to whether, is there a provision in the sanction order
Please,
that the landowner's right of entry will not be restricted?
Well, it is not the landowner, well, he is a third party. He claims a right of easementary rights in the land.
Is there, as a matter of fact, a
There is
condition
nothing, my
No,
lord.
in
There
the
is nothing.
grant, in the
Yes.
grant of the conversion order?
the grant is concerned, my lord, in the existing road is concerned. It is not existing road.
My lord, and he has
After
been given an
holidays?
alternate remedy.
Prayer also.
We'll have it after holidays. There's no urgency in the matter. Your all other rights are protected. You can approach the civil court if you have a right.
My lord, after completion of the building, he has approached.
Sorry? Pass over today.
So I told him for
Please.
today.
Your lordship may have it immediately after vacation.
After,
My lord, may direct to my lord, respond number 6 and to give on copy, my lord. They are not filed.
please serve copies on the other side. Yes, after vacation. Restoration rejected, 60 days delay, just after all this. Give a date. Suit dismissed with cause. Conversion.
Please, my lord, I am an advocate, my lord, I've been engaged to obtain a conversion. I obtained conversion. Layout plan is sanctioned.
Attention, finding of the court is that you did not obtain conversion.
Please, my lord, that is, my lord, that was wrong because, my lord, they all,
That's the thing. Yes, notice,
records may be called for me,
take out notice, let's.
please.
Yes, the records can be called
Appearing for the appellant, my lord.
in this matter. Records can also be called for. Yes,
Appearing for the appellant, my lord, we're
section 8 dismissed.
my lord, we're exploring settlement, my lord, it may be kept after vacation.
Please.
Yes,
Great.
learned counsel for the appellant submits that there is a chance of settlement between the parties just after all.
Lordship.
Hearing for the first respondent. Seeking leave of this honorable to file a memo. Because the 30th/8 order, it was already executed.
That is. May I submit? Your lordships had permitted us
Hmm,
to serve the copy of the appeal memo on the respondents.
hmm.
On 20th, we have given them the application, the appeal memo on 19th. On the very same day, they have executed. And I have brought your lordship's kind notice by filing another IA, stay of further proceedings pursuant to this attachment order. On that IA, your lordship granted the interim order.
There was no further proceedings is the contention.
There are no further.
Have this,
Hey, Today they have served a copy on me, the second IA. I have to file an application.
On the day he was not there, that is why we could not serve.
Kindly have
Have
it
it
after vacation.
immediately after vacation.
But interim order may kindly be extended. But interim
Yes.
order is they have attached and they should not deal with the property.
The memo filed by the respondents is taken on record. list immediately after holidays.
May I submit, my lord? Let them not deal with the property. That is the application which we have filed. And your lordships, my lord, your lordships
Common
have-
appeal is maintainable before this honorable. court.
Order, if any, which survives shall remain in force.
For appellants, my lords, in the previous matter, I'm sorry, my lord, serial number 4, lordship issued notice. Where I happened, the respondents have already entered K-8, my lord, notice may not be necessary. The fourth matter, my lord, in which I had. Notice anta. it was-
Notice render.
The notice was ordered, my lord. I'm sorry, I did
Okay.
not bring.
Okay, they're already on caveat.
Please, my lord, notice
Yes.
may not only records. The seventh, my lord, serial number, lordship
Yes.
has heard in on occasion.
Lord, I'm appearing for the respondent.
Ah.
I'm the proxy counsel. Kindly pass over, my lord.
Will pass or may not, some after
No
vacation.
question of any passing over. We are aware of the
No, I'm the proxy counsel.
limitation. The only issue is this. Can you go there and create a situation where he is unable to carry out his business? Only because of who you are.
Kindly pass over. I am the proxy counsel and he will.
Ultimately, you have to file a writ petition. You are aware of the situation.
Please, my lord, I am aware, but my lord, I just relied on the Bombay High Court judgment wherein section. My lord, I also made some research, my lord, Vidya Droli and other things. I will come up with little convinced citation because, my lord,
There is a
section.
time today.
Please, no, not today, some other day.
R2
Please, my lord, I'm
OSC. Yes,
in that R2 maybe.
yes. Notice to R2, list immediately after.
This matter, my lord, after vacation, I'll try to convince, my lord, just some. Yes. Obliged.
Suit was for ejectment and arrears,
Please, my lord.
vacated on 29/3/2024.
Please, my lord. During the
And
pendency
arrears
of
of rent and damages dismissed.
is rejected.
Notice,
Please,
notice to the respondent. Section 37 NH, enhancement of compensation. What was in compensation? initially awarded?
Compensation granted was 2,70,000 per cents, my lords. They have enhanced through 3,20,200, my lords.
Yes. You appear for
R2,
the,
my lords. I'll take
R2.
notice for R2.
yes, issue notice to R1.
R2 take note. And R3 may be dispensed, my lords.
R3 is the,
Dispensed.
yes. Notice to R3 is dispensed with. You want to stay?
Please, my lords.
There'll be
Similar
stay.
matters, your lordship has.
Yes, there'll be a stay of further proceedings in execution on condition that the appellant deposits 50% of the enhanced amount awarded with interest before the court below in, what was the time?
Lower
granted?
court, my lords. 6
In-
weeks.
6 weeks.
Lower court, my lord.
Yeah, before the law, before the commercial.
Lordship, I appear for the appellant. The section 34 court has partially set aside the award by appreciating evidence to my mind, which is not permissible. Therefore, I preferred this appeal, your lordship.
BDA,
BDA is the respondent.
issue notice to the respondent, the appellant is also permitted to serve notice on panel counsel and
On the counsel appearing in the lower court, if your lordship permits me.
panel counsel here
Right.
would be either on the panel counsel or on. Yes,
Very well. Great.
Appearing to the appellant, my lord.
MSME facilitation council.
Yes, my lord, in this, what
Contention is
happens?
that there is no proper consideration.
No, my lord, in this case, my lord, we get an award from the MSME.
Hmm.
And the act is very clear, without putting 75%, nobody can appeal.
Hmm.
However, the respondent files an appeal before the commercial court.
Hmm.
And the first order of the commercial court only clearly says that 75% is not, in fact, they don't deposit a single rupee also. My lords may have the order sheet at page 63. Page 63 is order sheet, my lord, the relevant portion order at page 64. Lordships have page 64.
Hmm.
Bottom two paras, I'll read, my lord. As per section 19 of MSMED, the petitioner shall deposit 75% of the award amount, but the office failed to comply this observation before registering the case. Hence, call for explanation from the concerned official in this regard. So, my lord, from the very first day of hearing till the final hearing, they don't deposit the 75%. However, the commercial court goes on and allows their appeal. Says principle of natural justice has not been followed, and the reasons, my lord, so my case is, my lord, it is not, their appeal is not even maintainable. Without depositing 75%, the commercial court could not have gone into the merits of the case.
The petitioner before the court was the bank.
Yes, my lord, the bank.
Should notice, is there any panel counsel? Panel counsel for the bank?
I'm not aware of, my lord. It's the first hearing, my lord. Emergent notice may be issued. My lord, in the meanwhile, I have filed an IA for staying the operation of the commercial court order. So,
Yes,
Yes.
take out notice, emergent notice.
My lord,
This
yeah.
Immediately after service is complete.
No, one request, my lord, serial number 75 also, my lord, I have today for order on maintainability. If I just mention it, my lord, because I have filed a commercial appeal, but it is not under order 43 of CPC. Therefore, I seek liberty of this honorable court to convert it into writ petition, my lords. Serial number
Yes,
75, my lord.
75.
75.
Yes, learned counsel for the appellant seeks leave to withdraw this appeal with liberty to convert it as a writ petition.
Writ petition.
Conversion to,
Yes.
with liberty to convert the same as a writ petition. The appeal is disposed, permission granted, appeal is disposed of for statistical purposes. Conversion, is it not easier to file a writ petition? Withdraw and file
And
it?
the thing is, we have filed all the certified copies in this appeal. Therefore, my lord.
Yes, returned to the appeal shall be returned to the petitioner for filing the writ petition.
Obliged, obliged.
75, please mark it. Yes,
Obliged.
Yes, sir. Okay, for appellant, my lord. Lord, it's an,
party injunction vacated.
party injunction has been
I'll get
vacated, my lord.
dismissed.
Will you
Posted to
dismiss?
2410 for evidence.
My lord.
Emergent notice list immediately
Wait,
after holidays.
My lord, for a moment, I seek for stay, my lord. Now, by virtue of vacation of interim order, my lord, the defendant number 3 is under proceed to sell the property, my lord. My lord, insofar as plaintiff is concerned, my lord, he paid the substantial consideration to respond defendant number 1 and 2. My lord,
From
even,
the emergent notice council.
my lord, stay, otherwise, if stay is not granted, my lord, it's going to be cause injustice, my lord. If the defendant number sold the property to some other person, my lord, third party interest will be created, my lord. My lord, the the only
Can be what is the reason for the vacation of the injunction? Have been granted. It has been vacated. Yes.
my lord, other,
List
my lord, is only grievance of the commercial court is, my lord, is an
No, this
unregistered agreement. Only on that ground, my lord, the court come to a conclusion. My lord,
Just a
Supreme
moment,
Court
just a
has
moment,
categorically held that, my lord,
which is the order vacating the injunction?
my lord, annexure A, my lord,
At page?
page 17, my lord,
Hmm.
page 17. Para number 12, my lord.
Defendant number 3 is the purchaser
Purchaser, my
of the
lord.
property.
Purchaser of the property, my lord. Substantial payment had been paid. My lord, 28,000.
Just a moment, counsel. Just a moment. Agreeing to sell the scheduled property for total consideration of 28 lakh and payment of 19 lakhs is paid by plaintiff to defendant number 1 and 2 through checks towards advance sale consideration. Defendant denied all the averments. Denied the sale deed executed.
Only grievance is, my lord,
Sale deed and that defendant number 3 has not acquired any right.
unregistered,
So denied that he has avoided legal notice. What is the finding?
my lord, claiming that, my lord, it's an unregistered document that cannot be relayed. That is the finding of the commercial code. That is incorrect, my lord. Supreme Court categorically held that the unregistered document is considerable under law insofar as the sale agreement is concerned, my lord. Only on that ground itself, entire amount was, substantial amount was reserved by the defendant number 1 or 2 through check, my lord, bank transaction. Even after issuance of notice, they are not, you know.
When was the payment according to you?
My lord, payment, my lord, back in the year 2001, my lord, 13/12, in the year 2021 itself, my lord,
Alienation to D3 is on 13/6/23.
23, within time, my lord,
What was the ex parte injunction which was in force?
my
Not
lord,
to alienate.
not to alienate, my lord.
Yes, issue emergent notice to
Further,
the
further,
respondents. List immediately after service is complete till the next date of hearing. There'll be a temporary injunction against the defendants not to alienate the suit schedule property till the next date of.
insofar as IA number 2, my lord, I seek further proceedings, my lord. Why I seek further proceedings, my lord, now is an agriculture land.
On 24th.
For a moment, it's an agriculture land, my lord.
Let it be,
Stop.
counsel, we are giving you a listing before
Well,
then.
Commercial,
We'll consider it. Yes.
for a moment, commercial suit itself not maintainable.
Counsel, we
The trial
consider
court,
that.
now the commercial court insisting me to withdraw the suit, my lord. That's why if a suit is withdrawn, my lord, this order will. My lord,
Yes.
further proceedings stays still necessary.
24th, counsel.
28th is the
24/10.
before commercial court, 20th date is fixed. My lord.
Please
please.
list it.
Please, ma'am.
Yes.
I pay for the appellants. I pay for the appellants counsel.
Section 34.
Yes, now in the 34,
Solar plant.
yes, I've already put up a solar plant.
Hmm.
One particular piece of land out of a contiguous area of about 200 acres has not been made over to me.
Hmm.
I apply for specific performance.
Hmm.
Page 98, learned arbitrator would pass an award which I don't think conclusively resolves the dispute.
Hmm.
What he would say is, if claimant is in settled possession, respondent can't dispossess. And he would go further to say, if I give up my claim for possession, they are entitled to 10 lakhs. This is totally arbitrary. Neither party pleaded this case that they are entitled to 10 lakhs if I give up possession. Please see page 99. This was placed before the commercial court. Please be kind enough to come to page 53 from the commercial court's judgment. The commercial court proceeds on the basis that the arbitrator cannot look into any element of fraud, which is which is legally not correct. Please look at para 22.
Hmm.
From the above stance taken by the respondent, it is crystal clear that respondent does not dispute signature on exhibit P6 and wants sub-registrar had executed so-and-so. His only contention, he did so under the impression he was getting registered an agreement in favor of land bank, and therefore, in essence, his contention is of fraud and misrepresentation. Learned arbitrator has quite correctly refused to go into the question of fraud. This is because the law is settled that the question of fraud cannot be gone into by an arbitral tribunal. This is wrong. Law has changed. Maestro engineering is no longer good law. All I'm submitting is that I am in possession, I've put up a solar plant. Be that as it may, that needs to be examined. Today, all I'm seeking is a stay of the enforcement of the arbitral award so that they don't take any further precipitated
Only
steps.
submission is
I'm sorry.
Sorry.
One other submission. I had deposited further 15 lakhs in the 34 court at the instance of the 34 court. That has not been noticed at all. Just to show my bona fides, I'm willing to deposit any further amount also if it becomes necessary. Therefore, kindly stay.
Mallots, we were on caveat. We received the appeal memorandum only on Friday. I'll file my objections, Mallots. Concurrent findings, the relief they have sought is for specific performance. They are in possession.
In the meanwhile, there is no proceedings in execution.
No proceeding.
now?
No.
Let that statement be recorded.
Yes.
Subject to correction, Mallots, I'll just verify. I'm told that.
In that case,
please.
court may grant a stay. I don't want to embarrass my lawyer.
Only Mallots may have it right after vacations. I'll file my objections, Mallots.
In the meanwhile, don't precipitate.
I won't. In the meanwhile, I won't.
List the so-and-so takes notice on caveat and seeks time to place objections on record. List immediately after vacation till such time. Proceedings, if any, in execution
Please.
shall not be precipitated.
Please.
Lots date may kindly be fixed.
Yes. First week of November,
Please,
October, Mallots.
whatever it is.
21st or 28th.
Much
28,
obliged.
great.
Notice to R2 is dispensed with. Second respondent is the arbitrator. Dispensed with, dispensed with.
I appear for the. The commercial court holds that the transaction is not commercial one. Without looking into the fact and the evidence on record. 1 crore loan was advanced to the first respondent firm who is the builder. And the loan and the build 5 flats are mortgaged in my favor. They create a fake release deed and they sell the flats. And there are other loans. They plead the discharge of the other loan and say they club the payments made to other loan and say this is paid toward that. We have produced the bank statement also. Without looking to that,
Yes, should notice to the.
my
respondent.
submission is I have sought for stay because
Stay
there are
for-
3 criminal petitions pending before this honorable court in regard to the 7 checks dishonored issued by the first respondent. Therefore, the judgment should not be used to disposal of those cases. Therefore, I have stayed for that.
Yes. Issue a major notice to the respondents. There will be a stay of operation of the judgment till the next date of hearing.
Better for the appellant.
Caveat to respondent.
Manpower services.
Matters.
Yes,
But in this matter, my lord, the arbitral award has been set aside by the commercial court on the ground that the principles of natural justice has been violated. The respondents were duly served or represented by an advocate. They failed to file their statement within time prescribed. They did not even cross-examine the witness, man. On that ground,
consider it immediately after holidays.
please, no.
Yes.
Well,
yes,
one
immediately.
sufficient, no?
Yes.
A sum of rupees 92 lakhs has been deposited by the respondents. That shall not be withdrawn by them with the interim order that have sought.
My lords, I am resisting that, my lords. Lordships may kindly see what happens in this matter.
List immediately after holidays. Till then, further proceedings shall not be precipitated.
Please.
Give
My
it-
lords,
We list it on a date council. Yes,
And LCR may kindly be called for.
yes.
Much of it.
Notice takes.
Only response have been represented.
Council.
May it pleases my lords, here, my lords, the impugned order, my lords, is not passed against me, but a third party who doesn't have a direct interest in the arbitration, my lords, and that too, an ad interim ex parte in future. The claim has not been crystallized as yet. If my lords will have page 55 of the impugned order. Without any reason.
Just a moment. Third interim measures of protection to the commencement conclusion of arbitration proceedings as between applicant and respondent hereto by way of directing respondent number 2 to deposit the insurance claim amount under the policy number so and so before this court in an interest bearing account or in any other so and so person directing so and so. Who is R2?
R2 is Oriental Bank.
It's the
in-
insurance company, my lord. They're not on record,
Hmm.
either before the Section 9 court or currently before this honorable court.
Hmm.
I'm the caveat respondent number 1, my lord.
Hmm.
I sought for the insurance amount that was due to the appellant here to be deposited before the commercial court to secure my interest.
Hmm.
My lord, please note the conduct. They appeared on the last date before the commercial court after the ex parte order was passed. They've taken time to file their objections before the commercial court. Without filing objections, they've now come up here. The matter is listed on 15th, my lord, which is right after this court reopens. They may urge all of their grounds there before the commercial court. In fact, my lord, there's a judgment of this honorable court, if I may just pass the citations, which clearly says, my lord, in case of an ex parte order being passed, where they can seek vacation before the commercial court, there is no reason for them to come in this appeal, my lord.
After you finish, let me know. This is my appeal.
Yes, what was the suit for?
My lords, they have not started the arbitration as yet.
We have invoked arbitration by issuing notice
When?
day before yesterday, my lord. It's already been issued.
Day before yesterday.
It's within the 90 days limit, my lord.
Very well. When you finish, let me know. This is my appeal. I'd like to
Please.
praise.
Yes.
You have finished?
Yes.
Thank you very much. My lords, will have the impugned order at 57. Why I am challenging it, my lords?
Can we pass this over?
Very well.
Pass over.
Very well, my lords.
For the appellant's counsel, very,
Extension of time.
yes, but there's a very interesting question here. The question is one of when the period of limitation, if any, for filing the 29A arises. Very quickly, what has happened, I'm familiar with this court's judgment when sitting in the Kerala High Court, I'm familiar with that, but that was on the question of
Whether it could have been
done after the award.
extended after the
Quite right.
award.
In
was
fact, I've
passed.
taken advantage of that judgment in some other case. But this will bring it to the court's attention. There is a recent judgment of the Supreme Court
Rohan Builders.
on Rohan Builders, 10th of September. I'm conscious of these two, but I fall in a slightly different category and I'll tell the court why. It's a very short and simple question. Question is, arbitration begins in 2018. 2021, the arbitrators are appointed. What would happen is that the pleadings are complete on 2011-21. Therefore, the 1 year period is from then. Let me assume the COVID extensions also available to them. Suo motu order. So that then they fall up to March 22. What would happen is that in between, one of the learned arbitrators passes away, unfortunately, and then there's a replacement arbitrator. There is an extension of time that is sought on 18/3/23. Even according to them, the period of cause of action for the filing is in November 22. Now the question is, if you have, and when they asked for my consent in 18/3/23, I declined consent. There is a very important reason. The important reason is the principal company against whom they initiate arbitration has gone into insolvency. I am a bystander, really speaking. They say I'm a guarantor. I say I am not. That's a matter to be decided. I'm not on, that's on merits. Now, the only point is, the question is one of damages and to say whether or not R1 performed the contract. Obviously, I have nothing much to say on that. I really cannot substantiate that. And therefore, it is going to be something that only they will have a say on. Now, what would happen is that if the period for filing of the 29A extension arises in November 22, were they justified in filing it in March 20? No, not even in March 23. They filed the petition in September, in April 23, 19/4/23, they would file it. Initially, there was some controversy over whether it should have been filed in the commercial court or in the high court, because at that point in time, there was an order of a learned single judge of this court, which said that the high court alone should be the court that would hear the matter.
That appears to be.
That is no longer the position. That is no longer. Basis that the matter came to be remanded back.
Kerala High Court judgment also proceeds on that.
Yes,
basis,
but now
because it was
there
before
is an order of the
Supreme
Supreme
Court that the extension came.
Correct. Now there's an order of the Supreme Court putting that matter to rest.
It was only because both were agreed on that question that
That's
question
correct.
was
That's
not.
correct. That's in fact correct. That's in fact correct. Now, therefore, if the court is pleased to see the impugned order, there's a very interesting observation that the learned commercial judge would make. The learned commercial judge also expresses dissatisfaction over the position of law, page 42 of the appeal compilation. Oh, I'm sorry. I'm sorry. Please be kind enough to come straight away to page 44. The entire narration, my learned friend appeared before the trial court. The submissions are recorded. Somewhere in the middle of page 44, there's something in bold which says, as per section 29A5, any party to the tribunal shall make a petition before the principal court of original jurisdiction. Right to prefer an application is given to both parties. Therefore, legislature in its wisdom has not specified any limitation for filing the application under 29A. Therefore, it can be concluded that the analogy for the advocate for the respondent, that the time specified in section 13(1)A of the Commercial Courts Act may be employed to section 29A of the Arbitration Act cannot be accepted. Though there is some force and logic in the submission of the learned senior counsel for the petitioner that Article 137 of the Limitation Act would be applicable. So according to him, it's 3 years. Under the 29A, the same cannot be accepted because the same is another extreme. So the court is essentially in limbo and says, I am not sure what the law is. Should it be, as was held in by the Supreme Court when it comes to commercial appeals, by reading the provision of the Commercial Courts Act into 37, that it should be 2 months, or it should be 3 years, as is contended? That question of law has been clearly something that has flummoxed the commercial judge. I'm only on that short question. Arbitration is today at 2:30. My request is to please stay, your lordship, please keep it immediately after the vacation. That's all my submission.
3 retired judges of the Supreme Court, my lords, comprise the arbitral tribunal. The arbitration has been in limbo, my lords, firstly because they refused to give consent for extending the mandate by 6 months. And then, my lords, what they do is they, my lords, play one obstructive tactic after the other. This is a classic abuse of process. The short point, my lords, there are 2 points again here which arise. One, is this appeal maintainable? the appeal is not maintainable, my lords, because under section 37, read with section 13 of the Commercial Codes Act, an appeal from an order of the court is contemplated only under three circumstances: section 8, section 9, and section 34. An order that is passed under section 29A cannot be appealed under section 37. And my lords, therefore, read with the embargo in section 5 of the Arbitration Act, where the court can only intervene in circumstances which are expressly provided for under the Arbitration Act itself. My lord, an order under section 29A cannot be the subject matter of a challenge under section 37. The matter should end there. And therefore, my lords, as far as the second question, which is on merits, etc., is concerned, my lords, there were three reasons as to why, my lords, the arbitration couldn't be completed within time. Firstly, my lords, the presiding arbitrator, former Chief Justice of India, Justice Lahoti, passed away. He had to be replaced. Justice Singhvi has been appointed. That entire process took around 2-3 months. The second aspect, my lords, the respondent, my lords, of course,
First respondent goes into
insolvency. So, my lords, this claim is really for, my lords, recovery of a sum of money which has been advanced to them for setting up of a microbrewery, of a brewery in Andhra Pradesh. You know, that sum has vanished. The company has very conveniently been engineered into insolvency. And, my lords, the guarantors are the parties who have been made parties to the arbitration. That issue has been confirmed, my lords, by an order of this honorable court, which of course has not very conveniently been produced along with the appeal. On 31/3/2021, this court passes an order, my lords, referring those parties to arbitration. The Supreme Court upholds that order, and the Arbitral Tribunal, my lords, dismisses the section 16 application, whereby they say we cannot be made parties to the arbitration. So all those issues are settled. In this appeal, my lords, there are two aspects that are challenged. The first is the issue of limitation, which my learned friend has argued. The second saying that, my lords, the law has now changed after Cox and Kings, my lord, they can't be made parties to the arbitration, which is not the case at all. As far as the limitation question is concerned, my lord, that is, in fact, has been answered, in fact, by the Supreme Court in its recent judgment in Rohan Builders, where the court says that it is not for the courts to prescribe a period of limitation where the legislature has not done so. My lord, in the Arbitration Act, there is no period of limitation for filing an application under section 29A. We, my lords, were under the bona fide impression that the parties will extend the time period. And of course, my lords, because of certain exigencies, the Arbitral Tribunal also didn't bring it to the notice of the parties that the mandate had expired. They have a counterclaim of around 150 crores. I have a massive claim as well. My lords, the trial court says both parties had the ability to approach the court. So therefore, my lords, I, of course, am the claimant in the arbitration. I want the arbitration to go on. I file an application, but they also have a counterclaim. So, my lords, this is a classic tactic of trying to disrupt the arbitration for one reason or the other. And my lords, kindly see, the order is passed on 10th of September 2014. The impugned order in this case. 10th of September, my lords, 2014. They wait for 20 days. The arbitration is scheduled for today. My lords, I think on Friday or Saturday, the Arbitral Tribunal says that now that the mandate has been extended, we are going to have a procedural hearing on Monday to determine the next steps in the arbitration. The arbitration is at the evidence stage. So, my lords, the whole idea is of having this matter listed urgently before your lordship is to try and scuttle that and try and escape this liability. So, my lords, as far as the question which my learned friend has very vehemently contended for your lordships, my lord, that issue unfortunately does not inure to the benefit of my learned friend because it has been answered by the Supreme Court. Justice Sanjeev Khanna's judgment, please pass on that judgment.
Rohan Builders.
Rohan Builders, where the court very clearly says that, my lords, when the legislature has not thought it fit to prescribe a period of limitation, then it is not for the courts to prescribe a period of limitation. And therefore, my lords, the traditional principle is that if there is a time period that is prescribed in the Limitation Act, my lords, that of course has to apply. And when there is no specific limitation period for a 29A application, the residuary provision under section 29 will have to come into play. My lords, kindly see the judgment in Rohan Builders. Para 2. The common judgment decides whether an application for extension of time under section 29A can be filed after the expiry of the period for making of the arbitral award. Then, my lords, kindly see paragraph 6. My lords, the second portion, starting with the sentence, the expression either prior to or after the expiry of the period so specified is ambiguous. It can be deduced by the language that the court can extend the time where an application is filed after the expiry of the period under subsection 1 or the extended period in terms of subsection 3. The court has the power to extend the period for making an award at any time before or after the mandated period. Then, my lord, paragraph 13. at page 11 of the judgment, my lord. Courts should be wary of prescribing a specific period of limitation in cases where the legislature has refrained.
Just a moment, sorry, paragraph.
Paragraph, my lords, 13, my lords, and I'm reading, my lords, on page 11. I'm so sorry,
Yes,
my
yes.
lords.
Yes.
Courts should be wary of prescribing a specific period of limitation in cases where the legislature has refrained from doing so. This is exactly, my lords, the answer to my learned friend's contention. If we give a narrow and restrictive meaning to section 29A4, we would be indulging in judicial legislation by incorporating a negative stipulation of a bar of limitation, which has a severe annulling effect. Such an interpretation will add words to widen the scope of legislation and amount to modification or rewriting of the statute. If the legislature intended such an outcome, it could have stated in the statute that the court may extend the period only if the application is filed before the expiry of the mandate of the arbitrator, not after. Indeed, there would have been no need to use the phrase after the expiry of the period in the statute. In other words, a rigid interpretation would amount to legislating and prescribing a limitation for filing an application under 29A when the section does not conspicuously so state. Rather, the expression and intent of the provision are to the contrary. Based on that, my lords, in paragraph 19, the ratio is we hold that an application for extension of time period for passing an arbitral award under 29A4 is maintainable even after the expiry of the 12-month period or the extended 6-month period as the case may be. The court, while adjudicating such extension applications, will be guided by the principle of sufficient cause, etc. Now, the second limb of my learned friend's argument is, even assuming that Rohan Builders has held that it can be filed even after, how much after? Can it be filed 2 months after, 3 months after, 6 months after? In this case, I'm told it's around 5 months after. On that, there is no prescribed period of limitation in the Arbitration Act or in the Limitation Act, which specifies within what period it has to be filed. The second aspect, both parties can file an application. We chose to file it. They also could have done it. They haven't done so. Their intentions are clear. And therefore, as far as the law on this point is concerned, the Limitation Act is clear. Is if there is no statutory period of limitation, then the residuary provision under section Article 137 comes into play. My learned friend's argument proceeds on an analogy. The analogy is under section 13 of the Commercial Codes Act, the time period for filing an appeal under section 13 is 60 days or maybe 90 days with discretion to the court. So therefore, if it is 90 days for filing an appeal, could it be the legislature's contemplation that an application can be filed after 5 months? The answer to that is Rohan Builders, where if the legislature sufficient cause and the legislature has not thought it fit. Under the Commercial Codes Act, there is a time period which the legislature has thought it fit to incorporate. In respect of 29A, there is no such time period at all.
Very you answer the
I'll answer very easy.
37.
Yes. First submission, my learned friend's contention that there is no appeal at all possible is clearly wrong in view of section 13 of the Commercial Codes Act. It's an order of the Commercial Court. So therefore that submission, let's not get into a debate now. We have enough to do today. Therefore that submission may not be correct. Second, he very conveniently, to borrow his phrase, broad brushes me along with respondent 1. I have nothing to do with respondent 1's contract in the sense that I am only, my lord, supposedly a guarantor. Can you say a counterclaim made by respondent 1 and me are one and the same? Of course not. I did not make the counterclaim.
You don't have a counterclaim.
No, it is the respondent number 1 who I'm instructed has made the counterclaim subject to being corrected. Third, Rohan Builders tells us the law as to which point in time of the proceedings the 29A can be done. It doesn't specify a time period. It does not go into that question at all. So therefore, Rohan Builders is not an answer to the submission that I'm making. 4, insofar as 37, since my learned friend is so heavily relying on 37 doesn't prescribe a period of limitation either. What the Supreme Court does in Borsay Brothers is to say, they read that along with the Commercial Courts Act to say that if it is an arbitration matter read with commercial courts, you will have to read it as being restricted to that. And therefore they prescribe 60 days. So therefore, when that can be done, and one has to remember that in the case of a 29A, the entire arbitration is supposed to get completed within a period of 1 year. And the extension is for 6 months. In that background, can I say, oh, I'll wait for 3 years and then file it and then regularize it? Suppose, please look at what will happen. Suppose the party loses in the arbitration. They will then use that to say that the proceedings were bad. Please see the consequences of what my learned friend's submissions are. Therefore, this cannot be treated as being the law when the Commercial Court itself has expressed that there is some lack of clarity in the law, my respectful submission is a matter that needs to be heard. Therefore, please hear me, it's our only respectful submission. This is all that I had to say on the matter. Insofar as stay, the only reason is that the proceedings are today. A learned friend can point out any number of calumnies. It is not as if his conduct has been free from blemish. Why did he not move the 29A before, as soon as the period came to an end, or just before that? What reason does he give? It's very easy to point fingers at others. Look at your own conduct. What did you do? Therefore, I would submit that this is a case where matter needs to be heard in some detail. Please protect me till then.
But kindly, that's just one point. I don't know, my learned friend seems to have a different version of the Commercial Codes Act. Kindly see section 13, which makes the point beyond doubt. Let's kindly see section 13(1)(a). Provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under Order 43 of the CPC as amended by this Act and section 37 of the Arbitration and Conciliation Act. So therefore, Manoj, section 37 does not provide for an independent avenue of appeal. If an appeal is possible in respect of commercial matters under Order 43 of the CPC or section 37 of the Arbitration Act, it is in those circumstances that an appeal will have to be filed in compliance with the provisions of the Commercial Codes Act. The purpose of section 13 is not to expand the scope of appeal beyond that what is contemplated in section 37. That is very clear.
An appeal shall lie from following orders and from no others.
From no others. So, Malaj, at the threshold itself, this appeal goes because an appeal is not maintainable.
When was 29A inserted?
Well, 29A was inserted by the Act of 2018, Manoj.
2310.
Of course, Malaj, in 2015 and then amended in 2018. Malaj, there were two amendments.
Initial was in 2310-15. The further amendment was with effect from 3819.
After in the 2015 amendment itself, there's been an amendment to
Yes.
section 37 as well.
Yes.
Section 8 has been made appealable.
Yes, quite right.
Therefore, it appears to be a deliberate one.
No.
The barring of an appeal
Yes.
from a 29A proceedings.
No, it is not a bar. I'll tell the court why. Please look at 13 again.
Yes.
Any person aggrieved by a judgment or order of the commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days. 1A, any person aggrieved by a judgment or order of the commercial court at the level of a district judge exercising ordinary original civil jurisdiction, or as the case may be, commercial division of a high court may appeal to the commercial appellate division of the court within a period of 60 days from the date of the judgment, provided an appeal shall lie from such orders passed by the commercial division that are specified, specifically enumerated under Order 43 as amended and section 37 of the Arbitration Conciliation Act. So therefore, there is no bar in saying that no other appeal shall lie. It is not a situation where, and ultimately this, if there is an order passed by the commercial court, if it is final in nature, I can understand if it's an interlocutory order, then I may have to move a writ petition or something else because revision is bad.
Says notwithstanding anything contained in any other law for the time being.
No appeal shall lie from any order or decree other than in accordance with the provisions of this Act. Correct.
Yes.
So my appeal is under 13. I'm very clear about it. It's under section 13 of the Commercial Code.
It must be maintainable either here or there.
It is not under the Arbitration Act. Let me be clear. It is not a 37 appeal. It is only a 13 appeal. It is only an appeal under 13.
That issue has also been settled, Manoj, the Jharkhand High Court judgment. Manoj, the Jharkhand High Court has said, Manoj, that there is no independent source of appeal under section 13. If an appeal could have been filed under Order 43 of the CPC or under section 37 of the Arbitration Act, Manoj, under...
Therefore, this has to be challenged in a writ petition, according to you.
This is the kind of splitting hairs they would do and then point fingers at me. But my submission is it's not correct.
Jurisdiction.
It is not a lack of jurisdiction at all. My submission is, where is the bar under 13 for me to file the appeal? That's the question I ask myself. Let him point out where the bar is.
The bar is section 5.
In fact, I want to point out, previously this appeal has been entertained. This my learned friend should bring to the court's notice. Please look at page 124. Please look at page 124. He doesn't appeal that. He doesn't raise his objection then. Please look at page 124 and 125. This was not pointed out to the court. In fact, the very same objection was raised.
And
one second. Let me point out. Since you pointed out Jharkhand, I'm pointing out our High Court.
Very good. Please.
Page 124. This is the interim order passed. Heard so and so, so and so. Appellants are before this court being agreed by an order passed by the commercial court on a petition preferred by the respondent in commercial A so and so, preferred under section 29A5. It is not in dispute that the order appointing an arbitrator by this court in CMP so-and-so by order dated so-and-so. Provisions read as follows. Then after the extract, on a bare reading of the provision, it is apparent that the reference to court, that issue is no longer res integra.
That is the interim order.
That is the interim order. Please see the final order. This was entertained. Appeal was entertained.
Please read the finding where it says that the court has jurisdiction. Please read
That's
that.
all right. I'll read everything. I can read the entire order. That doesn't change anything. The question is, did you raise this objection?
Prima facie, then the president has passed the order and so on. So that be so prima facie.
There's no finding, my lord. There is no ratio.
You did not raise this issue.
I raised the issue.
Then there should have been, then you should have challenged it in the Supreme
My
Court.
learned friend can't have it both ways.
Then you
First
should
says,
have challenged it in the Supreme Court. You are the one who's
both of
having
us
it both
can't
ways.
speak at the same time.
I am
don't-
speaking, so let me speak.
Let's-
The point is this, I was reading when you interrupted, just so I remind you. The point is this, please look at the operative portion of the order at 136. They remand the matter back.
Where is the finding, my lords, on section 37?
You have not raised the pleas,
My
my
learned
submission.
friend
Today
says
you
that
want to
I've
raise a
raised
plea
it.
just to
Now he
defeat
says I
me.
didn't raise it. Please don't interrupt me. I don't believe in this bull in the China shop side of advocacy, my lords, unlike certain others.
Then you must keep quiet when I'm
please
reading out. Come on,
clarify.
what is this?
Please,
Please, really.
We are arguing the question of law.
Absolutely, my lord.
Please,
I'm making a submission, my learned
Please,
friend is
please.
interrupting.
yes.
There is no finding. There is no finding, my lords. I've raised the objection. There is no finding. Then, my lords, we say that anyway, my lords, since they say that they haven't been heard, etc., my lords, by consent, it has virtually been remanded back. The Supreme Court in BGS Soma and the Jharkhand High Court have taken the view that, my lords, there is no independent source of appeal.
Just a moment.
Please look at page 130 for a minute.
135.
Yes.
However, keeping in view the aforesaid provision and also contentious contentions made by the learned counsel for the appellant and the learned senior counsel for the respondent, and taking into consideration the judgment of the Supreme Court, we are of the considered opinion that the appeal filed by the appellant is not maintainable.
It's not maintainable.
Therefore, without expressing any opinions of the merits of the matter, we proceed to pass the
Correct.
following order.
Appeal is not maintainable.
disposed of.
That's the finding.
Matter is remitted back to the court below for fresh consideration of the issues emerged in between the parties. Appellant is directed to file additional objections, if any. Court below shall decide the matter as expeditiously as possible.
So by consent, it was remanded back.
If the appeal is not maintainable, well,
That's a finding.
Let me read the whole thing. It is. The reason, what was pointed out was the learned single judge's order. That is the submission that I wanted to make.
learned senior counsel submits that
Yes.
though the appellant has preferred this appeal challenging impugned order passed by the court below, but the appeal is not maintainable. Preferred this appeal challenging impugned order passed by the court below, but the appeal is not maintainable. However, appeal is nothing but. a
Please see para
continuity
8 for a minute.
Yes.
Learned senior counsel also facilitated reliance on the Supreme Court and SLP so-and-so with reference to 29A. It is observed that the power under subsection 4 of 29A vests in the court as defined in section so-and-so. It is the principal civil court of original jurisdiction, which includes the High Court, provided the High Court under ordinary original civil jurisdiction. In this case, High Court does not have any ordinary original civil jurisdiction. Power under 29A is only a consequential power vesting with the court, which is empowered to extend the time. If the court finds that the cause of delay is one or all of the arbitrators while extending the time, court has the power to replace and substitute arbitrators. Said power has to be exercised. Learned senior counsel submits that the appellant has preferred this appeal challenging the impugned order, but the appeal is not maintainable. However, an appeal is nothing but a continuity of proceedings, and more so it requires revisiting the impugned order passed by the court below. Therefore, it does not require dwelling into the details of the material. In this context, it is relevant to refer to section 151, etc. That is all that was done. So for him to say this is a finding may not really be something that inures to his benefit. All I'm submitting is that now if you say that the appeal was without jurisdiction, how do you consent to an act of without jurisdiction? How do you consent to an order that's without jurisdiction? That also could not have been done. Therefore, all I'm submitting is today, there is the question of whether or not an appeal is maintainable also needs to be gone into. It is not as if there is a clear bar. The only bar is one that is what my learned friend says is Jharkhand High Court. I have not seen the judgment. I'll also look into it. The only point is today this. The principal person who has, against who you have a damages claim is in insolvency. In fact, we point out that there is insolvency against him. They say, no, we'll leave. There'll be a stay of proceedings against R1, but it will continue against the others. Now I ask myself what predicament I am being put in. Therefore, I did not consent to it, and rightly so. For him to say that all the fault is on my shoulder is totally wrong, because that is borne out from the record. He could have moved an application earlier.
This is it not for the tribunal to
No,
now
no,
consider whether you should be proceeded against in
The
in the
tribunal
fact-
has considered it. Tribunal did consider it. That order has been placed by me to say that it is virtually like in a criminal proceeding, splitting of trial. Now, what is it that I can do? Can I point out and defend the claim to say, no, the damages claim should not have been granted. The performance was good. I had nothing to do with the performance of the contract. How is it that I can defend that? And if that can't be defended, I ask myself the question, then essentially what they want is a fait accompli before the arbitrators. It may be 3 arbitrators from the Supreme Court or from anywhere in the world, but ultimately they're creatures of contract. That's all my submission is. Therefore, there is no, all I'm submitting is that when there is CARP against them, that's one aspect of the matter. This question needs to be gone into. Ultimately, there is no clarity on what the period of limitation is. All Rohan Builder says is the point in time of the proceedings when it can be filed. They don't say you can file it after 3 years. That is a contention that is sought to be advanced. That will in fact defeat arbitration even more, is my submission. Therefore, that question needs to be gone into, is my submission.
All those aspects of merits are merits not for the 29A court to decide. That's all for the tribunal. The tribunal has decided, this court has decided, the Supreme Court has decided, my lords, by referring them to arbitration. It's as simple. I'll just pass on those judgments, my lords. A very detailed consideration of the circumstances.
We are not on the
That's on
question
merits.
on the merits at all.
At
We are
all.
on
No, I'm
the
not.
question
It's
of
on
maintainability.
maintainability and secondly,
Yes,
my lords, in respect-
primarily on the question of maintainability.
and the hearing is today.
Hearing is today at 2:30.
And it is for next steps in the arbitration. Evidence has to be recorded. Final submissions have to be heard. Parties have to file written submissions. No prejudice is going to be caused to anybody if the proceeding continues.
No prejudice will be caused to me if an award is passed against me. Is really this is the first time that I've heard of such a submission. I'm really puzzled by the submission.
Recorded. Where is the question of passing of the award? Where is this artificial urgency that my learned friend has sought to portray? And if there was in fact such an urgency, would he have kept quiet from the 10th of September till today? Well, it's evidence has to be taken. Parties, witnesses have to be heard. Final submissions have to be heard. An award has to be made. Well, it will take not less than 1 year. That's the reason why we asked for an extension of 1 year.
The submission is that the certified copy came to be issued late. That's why I'm before the court as soon as I can. In fact, it's still not issued. I've applied on the basis. The certified copy is still not been made available to me. That's why there was some delay in moving the appeal. There's no difficulty about that. Also, for him to point fingers at for everything is totally without any basis. All I'm submitting is this. Today, we are in a situation where this question has been really left open by the commercial judge. The commercial judge is unable to reach a conclusion. That is clear from the order which I read out. He says what he says is also something that cannot be accepted. What I say is not found in that analogy that we use Borse brothers for is also not really something that he can make up his mind on. What should be the correct position of law? There is, to my mind, not a single judgment which lays down the specific period of limitation. Therefore, that question needs to be gone into. Whether it's in the form of a commercial appeal or a writ petition, I ask myself what difference it makes. The reason I make that submission is that under 13, there is no bar in my filing an appeal.
The difficulty would be of this court
I bow down.
to pass an order in a case where there is no jurisdiction.
I bow down.
Unless we feel that we have jurisdiction. How can we pass an order of stay?
Very well. In which case, if this is the vociferous objection, my respectful submission is that please give a finding on that, even on that point. Ultimately, the question is this. Under 13, there is no real bar, is my respectful submission.
Heard both sides.
Great.
The learned senior counsel appearing for the appellant submits that the appeal is one preferred under section 13 of the Commercial Codes Act, and that the appeal would therefore clearly be maintainable. Full stop. The learned senior counsel appearing for the respondent, on the other hand, contends that the appeal being from an order passed by the commercial court under section 29A5.
Yes,
29A5.
29A5 of the Arbitration and Conciliation Act. And since no appeal is provided therefrom, either under section 37 or under section 13 of the Commercial Codes Act, the appeal as such would not be maintainable, and this court cannot consider the prayer made for stay of the arbitration proceedings, since there is no jurisdiction in this court to consider the same since the appeal would not be maintainable. We have considered the contentions advanced. We notice the provisions of the Commercial Courts Act, especially section 13, which reads as follows. Section 37 of the Arbitration Conciliation Act provides that an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decrees of the court passing the order. The specific instances where appeals are maintainable from orders are also referred in the section. Further, Section 5 of the Arbitration Conciliation Act also provides that no judicial authority shall intervene except is it the same part?
My lords, yes, my lords.
It's the
Part
same
2
part.
is international commercial
Yes.
arbitration.
Shall intervene except where so provided in this part, full stop. In the light of the specific provisions of section 13 and section 37, section 13 of the Commercial Courts Act and section 37 of the Arbitration Conciliation Act 1996, where an order under section 29A is conspicuous by its absence. In section 37, we are of the opinion that the appeal would not be maintainable.
Great.
Keep your price.
Please permit me then to withdraw and move a writ petition.
Yes, the all contentions are left open.
Please, I'm very great.
Decided in appropriate proceedings.
Great.
Grateful.
Accommodation after vacation.
Yes,
My lord, I appear for the respondent in this case.
yes, are you on notice?
My lord, serial number 18, my lord, I appear for the respondent. Yes,
You are
we are
on
on
notice.
notice. Yes,
Immediately after audits.
please. Exactly.
The respondent thoughts.
Appeal by the Waqf Board. After holidays.
Lords, they are not appearing at all, lords. Last time also they are not appeared, lords.
We'll list it immediately after holidays.
Some date may be given.
Yes. Rectification of office objections. After holidays.
This matter, my lord. My learned friend has to file the judgments. In fact, there is, my lord, the very clear, my lord, what my learned friend contended on the last occasion. I'm not arguing the matter on merit.
Notification for acquisition stands set aside,
Yes,
against which the
yes. My-
board is in appeal.
Please, what my learned friend contended on the last occasion is no order passed by KIDB under the KIDB Act lapses by efflux of time. And therefore, the learned single judge's order needs to be set aside. But my lord, the prayer was, he is right, 50% is right. The writ petition was filed seeking for a prayer that by efflux of time, it my lord extinguishes. But the honorable single judge goes into the merits of the matter and says no order under 28.3 is passed, and therefore there is no question of my lord 28.4. He doesn't go into the question. Of course, my lord, I am not precluding my learned friend from my lord filing. May I persuade your lordships to see?
Just a moment, is this the question which is gaining the attention of the apex court in SLP? There
No,
appears to be.
that the issue is settled. My lord. That the extinction of the, my learned friend himself quoted that judgment in Nagbhushan's case, which is my lord at page 14, my learned friend has quoted. From there on, my lord, that issue is well settled.
What is Anita Purnesh?
Anita Purnesh, my lord, I am not aware. He, my lord,
They condoned, looking at the facts of the case, we do not find any merit in this petition, especially if petition is
Yes.
accordingly dismissed pending application of any.
sorry, this I produced, my lord,
Yes, that is
to
already
say
dismissed.
that SLP is based on which this order is passed is dismissed. The writ appeals that your lordships may see, I have produced it for this reason, my lord. Lordships may see page 19, my lord,
That is Anita Purnesh, 19, my lord. Anita Purnesh versus so-and-so. This is the judgment which formed the basis for allowing my writ petition. And therefore, my lord, Anita Purnesh
SLP is
SLP
dismissed.
That's all I'm saying.
That is
One
confirmed.
aspect. One aspect. Second aspect is, my lord, my learned friend says that by efflux of time, it does not extinguish. Kindly see, my lord, page 21, or even before that, the prayer, my lord. He's right in saying that my prayer was that. But the,
Page 21 of what?
sorry, page 16, my lord. My apologies. Writ appeal.
Yes.
Sorry. The writ appeal is filed under so-and-so, so-and-so, and the prayer is, my lord, hold and declare that acquisition of the land and so-and-so, so-and-so lapsed on account of section 24, so-and-so. That was my prayer. But kindly see the order, which your lordships will get at page 21. And the reasoning also, that the impugned notification as well as acquisition pursuant to are quashed insofar as subject lands are so-and-so. It is not on account of the Honorable Court does not say lapsed, it says quashed. Because your lordship saw, my lord, that Anita Purnesh judgment and all other judgments that followed, none of which are, my lord, they are all confirmed. All of them have attained finality and SLP dismissed.
The KIDB has neither passed any order under
Yes.
28(3) of the Act, much
Please.
less issued a final notification under 28.
That is the reason, not on account of efflux. That's all I'm saying. Therefore,
We'll file a written submission and meanwhile we'll file a judgment.
is there in the, because the SLP
file
is
it, my
dismissed. No,
Kind of.
filing, my lord, for satisfaction, I'm not coming in the way. But I'm saying SLP is dismissed and the Honorable Single Judge's order is very clear. That may be, otherwise, my lord, again, it will have to be reinstated is what I'm saying.
Learned counsel for the appellant seeks time to place written submissions on record. It is submitted by the learned counsel for the respondent that the judgment of division bench of this court, which is relied on in the by the learned single judge, has attained finality by the SLP being dismissed as early as on
Yes, that is, my lord, page
5/8/2000.
5/8/16, my lord.
And therefore nothing survives for consideration in this appeal.
And that, my lord, it is not on efflux of time and the Honorable
It is
Judge.
further submitted that the learned single judge has quashed the notification insofar as the properties in question are concerned on a finding that the KIDB had neither passed any order under section 28(3), much less a final notification under 28(4).
That's all I'm saying.
And it is not a question of lapsing by flux of time.
That's all I'm saying. Let him not
Yes.
re-agitate and trouble your lord.
List up.
Serial number 26 was also.
Same.
Application. The point is, my lord, check issued by the KDB was.
Now,
issued-
just a moment. We'll
Alright.
come to that. Just a moment. This is 22. 22. Yes, just a moment. We'll
That's all
come
I'm
to you.
No, in fact, on the last occasion, my lord has instructed me that this matter would be taken along with the.
Need not be, my lord, because
Acquisition has
Acquisition
been set aside.
Set aside.
Your contention is that there was already an award.
On the issue of stop payment, my lords.
I have opted for consent award under section 29(2). Check, wait.
Please wait. We'll just come to that. Just a moment.
Please, my lord.
So on
Since
this-
it was indicated to me that, that's why
I'm saying, my lord, on this count alone, instead of we fighting over these issues, my lord, since the matter has attained finality, I'm only imploring upon my learned friend not to. Again, written submissions, my lord, on these issues will be a trouble of, again, we'll be re-troubling your lordship.
Yes.
Appearing for the appellant in this case.
10 lakhs in lieu of reinstatement, software
I
engineer.
request for pass
Appear
over,
for
my
the
lord.
respondent.
Not to pass over today, comes.
Will-
Pass over today is not possible. We'll list it.
This may
immediately
require
after
some
holidays.
time, my lord. This will require some
Immediately
time.
after holidays. This is the in lieu of reinstatement amount is granted.
Yes, my lord. Court, after examining it, found, my lord, that only compensation can be
After
awarded.
Date may be fixed, my lord.
Yes, give a date. Not Mondays, 4th November. 4th November.
Very well. 4th November.
Much
Great.
Petition, my lords, it's await government.
Farmlands abolition.
So government
await notice.
await government or like the government was supposed to find out whether there was any order being passed, my lords. No, there is a
HA
direction,
for R2 to R4.
there is a direction given on the previous date of hearing.
Please serve a copy.
My lords, kindly look into the direction which has been issued on the previous date of hearing. They were present, copies have been served. Matter was heard at length. A direction is issued in this matter, my lords, to them. Directing them to find out whether,
Whether there is 1975
please.
grant in favor of father of the respondent number 1, whether he has relinquished his right in survey number 54.
problem.
I-
Sorry, my lord. My lord,
All
on this matter, I'm filing an endorsement, my lord, issued by the Tahsildar's office stating that there is no grant
In
in
1975.
1974. There are no records available.
No records.
Please
No-
make it.
No
please-
records in the
Please
sense.
file it. We'll consider it immediately after.
After vacation. My lord,
Yes.
there is another endorsement I'm awaiting. Both English translations, I will file it within the course of this vacation. It may be called after vacation.
Yes. This
Not
immediately
in
after.
this,
Can I-
so far
can I
as
be-
the order passed by.
Counsel, let the endorsements come before you argue. You will anyway have to argue when it is here. List after holidays. Yes, 28, 26. Yes.
Please.
What is the issue here?
My
It's
lord,
not the same land. It is not the same
Like
land
it-
as in item 22. Okay,
It's a
yes,
different land. Lord,
Yes.
So I have opted for getting compensation on the parameters of 29(2).
Hmm.
In the year 2007 itself,
Hmm.
when the notification for acquisition was issued.
Hmm.
And there was an agreement between myself and the KIDB. 1 crore 2 lakhs was the compensation arrived
Hmm.
and check was issued.
Hmm.
So on my the presentation of the check, it was dishonored at the instructions of the KIDB.
Hmm.
Thereafterwards, despite my representation to them,
Hmm.
so no, developments taken place. Either they have offered me to pay the same amount or less than that.
My lord,
And subsequently,
senior will argue the matter. Senior likes in other court.
are you?
and what happened?
Kindly pass on.
Bypassing,
Waiting
bypassing
for
the
No,
No,
yes,
restric-
wait for it to lapse.
kindly pass on.
bypassing the restrictions under the, act. So they have passed the general award. So I have, challenged the very passing of the general award and sought for quashing of the,
Have
so
this
that-
immediately after holidays.
please.
Yes. Discharge from service,
For respondents, my lords.
7/8/2015. ACS probation rules rural area certificate. Question, there is a question raised as to whether it was a rural area or not at the relevant time. Has that been answered?
That is not answered.
That-
certificate issues is false certificate is what is the observation.
That is all that is stated. Whether that finding is correct or not, you can easily tell us. There's no difficulty. Whether the area in question was, that is all. Yes.
He's claiming rural.
Yes,
category
if
was-
as a matter of fact, he has not stated anything false, should he be sent out of service?
Professional-
Please, probationer, it is discharge of the probationer, but for discharge, there must be a finding that there is some false. The deputy director seems to say that it is not rural area at the relevant time. There is a dispute raised. Please tell us, is that correct or not? If it is not a rural area at the relevant time, you're right. But that has to be decided first. This is a person being sent out. Yes, learned government advocate to get specific instructions in the matter. List immediately after holidays.
8 minutes.
Change of khata, remanded to the Tahsildar.
Please.
Notice has been,
Notice
delay
has
of
been-
40 days is, notice service is complete,
Notice has been ordered. I have paid the process fee. It has not yet been.
service is
The
complete,
last,
served and not appearing.
one,
Then the delay can be condoned, we can list it for admission.
immediately after.
Yes. IA 1 of 2022. This is an IA filed for condonation of delay of 40 days in filing the appeal. Learned government advocate has taken notice for respondents 1 to 4. And notice to respondents 5 to 9
Please.
is served. And they said they're represented.
Council's name has been represented, shown in the cost title.
in
Delay may
the-
be condoned.
In the above view of the
Eight.
matter. And in view of the averments in the affidavit filed in support of the application for condonation of delay. and the submissions made by the learned counsel for the appellant, the delay of 40 days in filing the appeal is condoned. List for admission after.
Please.
Housing Board,
Housing Board.
acquisition has held to be lapsed on the ground that compensation is not paid.
But one of the
Civil-
survey numbers was not notified. my lord.
No,
That's
there
the
is,
finding.
the issue is, there is an award amount is deposited in civil court in OS number 8034 of 1992
Ah.
on 38/1996. If that is so, then the finding is incorrect.
But it appears that actually there are 2 or 3 survey numbers. my lord.
Hmm.
Out of these survey numbers,
Hmm.
kindly see my lord, para 3 of this,
Hmm.
of the judgment.
Hmm.
Grievance of the petitioners that Housing Board had acquired lands belonging to petitioners and so and so, so and so. There are about 3 survey numbers, my lord, disputed survey numbers.
Hmm.
It is stated in the petition that no award has been passed in respect of survey numbers 22/3 and 22/4.
Hmm.
And further possession has not been taken. In that view of the matter, the acquisition made by the respondent authorities in respect of the lands is lapsed. This
Hmm.
was our contention, Lord.
Hmm.
Then appearing for the content in respect of land bearing 22/2B,
Hmm.
the said land was not notified in the preliminary notification. However, it was included in the final notification.
Hmm.
And final notification has been issued in respect to in which survey number 22/4.
Hmm.
But the same has been acquired by the respondent authorities and respondents have initiated the proceedings in respect to the lands. We
Hmm.
further contend that though the preliminary and final notification has been issued,
Hmm.
no award has been passed in respect of 22/23 and 2/4. So far as award is concerned, Lord, that
Hmm.
is the thing. But so far as 22/2B is concerned,
Hmm.
it is a finding of the court that it is not notified. 2B. And 22/3 and 22/4, since they are saying that there is a deposit of the award.
Just a moment. Yes, 22/3, 22/4, 22/5. That
Correct.
is, there is deposit of the amount.
Yes, Lord, Basha, right.
22 your property is in 22/2?
We are 4 segments,
Hmm.
4 properties,
Hmm.
22/2B, 22/3 and 22/4.
22/3 and 22/4,
4.
1 acre 16 guntas, the award has been passed. The
Really?
award amount has been deposited in the civil court.
Where is it? Where is it? But they have enclosed, it appears they have one, I'll just clarify.
Please clarify the extent.
Yes, yes.
Is this correct? This is your contention. What the, where? Yes. We'll have this
After
immediately
vacation.
afterwards. Yes.
But I'll also verify that position. It appears there is an award.
Respect of 1 acre 16 guntas, the amount has been deposited in the
Deposited.
civil court. If that is not noticed to hold that it is
Yes,
uh,
let
lapsed,
them,
then it may be a.
if
an
they give
error.
us the details, we will also check.
The details are available.
Details. give-
38/1996, they've deposited the amount in the civil court.
We will check it.
In OS number 8034,
Not, what they say
That
is,
pending in an RFA.
yes, that what they say is that that is with respect to 22/2, but I'll check it. Factually will,
Could be available, the
yes,
decrease
yes,
is there.
factually
So
will
the
check.
Extent and details will be available.
Yes.
Please
yes,
tell
yes,
us
Yes, please,
immediately after holidays.
please.
Learned. Government advocate takes notice.
Case number ಕೊಟ್ಟಿದ್ದಾರೆ, RFA bill.
Yes, notice to respondent number 3. State for respondent number 3. So and so takes notice for respondent number 3, so and so takes notice for the other respondents, list after. Yes,
If you were the applicant, may I request for a passover.
This may not
Are-
be,
assumption of agricultural land.
no, that
Immediately.
maintainability and on merits, it may take time. Will not trouble your. life.
After,
Yeah.
Any specific
Yes.
date, will not, because he is in possession, my land, any specific date.
Yes,
Ex-serviceman suffering,
yes, yes,
30 years.
assumption. We've seen the matter, but
Yes,
we
I
don't
go
have
down.
time to
go down,
consider today.
whenever you are.
Yes.
publish.
Responding. Writs
Rule
filed by the
32
state
promotion considered with
with retrospective effect from the date they are placed in independent charge. They were placed in independent charge in 2015. They are seeking they were regularized in that post from 2018. They were actually promoted. officiating promotion was given in 2018. Lord, in similar matters, interim order has already been granted
And that day, I filed a
on
walk,
20th.
caveat, I filed a caveat, man, is not put up. But similarly placed persons, those who are independently not placed under Rule 32, being already promoted. And based on that only, I approach the KSAT.
Just a
KSAT
moment, what is the finding?
Finding, not kindly come to page 17 onwards. madam.
Finding is on the ground that similarly situated persons have been granted such
Settled
relief.
possession of law, that's once a benefit has been extended to the official based on the order and their eligibility, and the said benefit has to be extended to all those persons who are entitled or required to be in the benefit without driving them to the court. Yetti Veerappan.
Is being already given effect to not all the similarly placed persons, except me. The finding of the KSAT is the same, lad, by virtue of Supreme Court judgments.
Respondents are hereby directed to consider the case of the applicant in the light of the recommendation of the second respondent and to the first respondent to accord retrospective promotion to the applicant in terms of recommendation letter dated 28/5/2018 and extend benefits. Lokesh Kumar, Nagbhushan, Nataraj, Srinivas, Shivanand Reddy. Are the writ petitions filed by you in these cases?
No, no,
No, man. My lord,
that
it is
they are
said
not
that they are
challenged.
different, my lord, their position is different.
Hmm.
And there are other persons who will be affected if they are given retrospective promotions. But all these matters may be taken up together and disposed of, my lord. Notice and stay has been granted on 20th.
That is on my
Take
absence.
notice on behalf of the respondents, list along with
But,
WP
WP 23077 of 2024.
Immediately after vacation.
077 of 2020.
Interim order.
Yes. What is the interim order there?
Lord,
Not to precipitate contempt proceedings. I will not.
Yes.
Till the disposal.
stay of the operation of the impugned order.
No, that was not.
Kind,
Stay, not to precipitate. anta madam.
not to.
Not to precipitate
not to-
contempt.
Yes, the learned counsel for the respondents admits that the contempt proceedings will not be precipitated till the next date of year.
Immediately after vacation.
Yes, list along with immediately after.
The matter at serial number
33 also.
33 is also similar.
Yes, that is also Rule 32 after DPC.
Similar, man. Same. They're all part of the
Yes.
same batch.
Yes, same orders in 33 also.
Date,
32,
date,
verification of marks appointed thereafter for seniority with batch meets. Yes, learned government advocate takes notice on behalf of the respondents and seeks time to get instructions list after holidays. What is the interim order we can grant? Can be corrected if you are found to be eligible. Yes. We understand, therefore, it can be rectified if required. Yes. Yes.
Additional AG appears in this matter. madam.
Captive
It was
generation,
Now this
generating plant.
Issue is
exemption.
covered. Now its issue is covered by the latest judgment of the
Immediately
council.
after vacation, any date may be fixed. My lord, additional AG is appearing in this matter. This has come up out of the,
Right.
without any date, my lord. So that's why I'm requesting that
Last
it
time
be,
I had
the
been-
date may be
Matter.
fixed.
In fact, I had informed the additional advocate general that it is covered by the judgment of the Honorable Supreme Court, but
I shall inform, my lord, immediately after vacation, a date, my lord,
2012 matter.
or it may be passed over, my lord, then.
Can't be passed over today.
I-
Yes, learned government advocate submits that the learned additional advocate general appears in the matter and seeks a short accommodation. Learned senior counsel appearing for the respondent submits that the matter stands squarely covered by
well, it's two judgments. We'll just pass it on.
decisions of the apex court in
So in that, your lordship takes the in page 3, page 4, my
JSW
lord.
Steel Limited,
Dakshin Gujarat, civil appeal number,
Chief Electrical Inspector.
please come to page 76 minutes, 75, 76, running page, the lordship should get.
Vadodara Power Private Limited versus
But
Gujarat.
the earlier ones are not required. Dakshin Gujarat Which Company Limited.
Hmm.
At page 75.
Gujarat, I'm sorry.
Yes.
No, that is not the judgment. stands covered by a judgment of the Apex Court in Messrs. Dakshin Gujarat VIJ Company Limited versus Messrs. Gayatri Shakti Paper and Board Limited and another. Yes, we list it immediately after.
Please.
Any date till.
Court officer, don't give to me on 21st. We'll be voted on. So many matters were already posted on 21st. Okay, that's it. Yes, 35.
I appear for the
Yes,
respondent.
my lord, last time your lordship has heard this matter for some time.
Mm.
Adjourned this matter, my lord, to find out whether in the rules, the special recruitment backlog recruitment rules,
Mm.
if a person, my lord, a reservation is made for a man, my lord, if he is not filled up, whether it could be transferred to the woman, my lord, that was the question, because
No, my lord,
the question involved was, in the backlog appointment,
Council
ST
will either have to hear this or
Yes,
list
madam,
it
yes.
immediately after holidays.
yes, my lord, immediately after holidays, my lord.
The thing is, my lord, it has not been implemented for the last 1.5 years, and the contempt petition is also pending consideration. My lord, Lakshma kindly say the short question, my lord.
Pass over. Yes, 36.
Sir, I appear for the respondents 1 to 4. I will have to file my objections in this. Impeding application is just served. I will file my objections immediately after vacation.
Yes, learned. You appear for?
R1 to R4, Your Lordships.
Learned counsel appearing for respondents 1 to 4 seeks time to file objections to the impleading application list immediately after holidays.
Much obliged.
R1 to R4 is the state.
5 days. R1 to R4.
37. My lord, can it be taken up at 2:30, my lord? I'll just submit my, this one. Only preparing, it's ready, my lord. Just submit my written submission.
2:30.
2:30.
2:30, we'll take it together at 2:30.
I'm just verifying the validity of a judgment, my lord, on which I'm relying.
Yes.
That's it.
Appearing for the appellants, my lord.
NHAI,
Please, my lord.
3 days in filing the appeal. Notice has been ordered.
No, my lord.
Notice in the COMAP and in all pending applications.
My lord, we have filed an interim application for the stay and subsequently for the condonation of delay. The same may be passed. My lord. The order may be, humble submission is, if it may be heard and an order on the delay condonation may be passed. My lord.
Delay condition cannot be passed without notice.
Please, my lord.
Notice may have to go and come.
Please.
In the meanwhile, you'll deposit.
My lord, in that regard, I intend to give a judgment provided by the High Court of Karnataka Division Bench, my lord, if I may.
What is this about?
Regarding the
Not
deposit,
with regard to enhancement.
regarding the enhancement, my lord,
Hmm.
subsequent to regarding the deposit for the interim application of stay,
Hmm.
there are the rule by the power conferred by the section 2 of the NH Act,
Hmm.
rules are framed. That is the manner of depositing 2019 rules,
Hmm.
which provides for that particular rule. If I may read, my lord, I haven't watching.
Pass over, we'll hear you.
Please, my lord.
Present the, here for the respondent.
Present the appellant, your lordship. If your lordships recollect, on the previous occasion, I made a submission that it is a recovery suit filed before the commercial court. I filed wakalat before the commercial court, but I did not turn up and file my written statement. Summary judgment is passed. Execution proceedings have been initiated. Till date, I am deposited 64 lakhs before the execution court. My only submission before this court is that only point which is involved in the present appeal is if I am provided an opportunity with proper.
What was the reason for the delay? Here also the appeal is filed with 721 days of delay.
721 days delay.
What is the reason?
The appellant has undergone medical surgery. I have produced the documents at page 55 to 60. He went an art surgery. where he was not able to communicate an advocate and he was not able to move around. That's the reason he was not able to file the appeal in time.
Milords,
Is already on notice. You are appearing?
I'm appearing for the respondent, will not permit me to file objections because the reason given for the medical certificate is only pertaining to 1 month, my lord. Prior to that, over 1.5 years has passed. And I've also
Yes.
submitted the last.
File your objection, then we'll hear it on the merits. The IA on merits, yes. Learned counsel for the respondent seeks time to place an objection on record. List immediately after holiday.
Yes, Your Lord. Several opportunities were given to the respondent to file objections, but till date it has not been filed. If your lordships may kindly peruse the.
Is that
Milord,
so?
Milord, what happened was the case was being listed on the last date. The interim order of stay was vacated because they did not comply. And in fact, the case was, if I have not mistaken, been ordered to be listed after vacation.
No, why have you not
Yeah,
filed your?
what has happened is
objections?
I had discovered on the last date that there is another matter, commercial laws 163 of 19, which they prosecute during this COVID period. I have applied for certified copies to show this court.
You told us that last.
Yes,
posting
I have
last
applied. I had discovered just before that hearing. I've applied for certified copies. I'll file it along by objections.
Yes, last chance.
Grateful.
Notice. Notice.
For the appellant, my lord, raise additional time to deposit the money, my lord. We have to pay the.
Non-depositing of amount of 2,83,507 with 9% interest.
Requesting Honorable Court to
16,724.
requesting time, my lord.
Time to deposit the entire amount?
Yes, my lord. Will be 2 months time required for. We have taken many hand loans, appellant, so we are unable to pay the amount.
Unable to pay 2,83,000?
Ma'am.
You are an interior decorating firm? Yes, just immediately after holidays. If the stay is not there anymore.
We'll be depositing.
Stay. Yes, make the,
We'll deposit.
if you deposit, there'll be a stay. Then we'll consider, yes, list immediately after holidays.
Achha.
Appearing for caveat and respondent, my lord.
Sorry?
Appearing for respondent, caveat.
Yes. Any objection to the delay being condoned?
Delay
15
may be
days.
condoned, but the,
Listed for admission after that.
no,
My lord.
they have filed application for stay, condition of stay may be.
Requesting for a time after the vacations.
We
You
have
don't
already
wa-
filed execution petition.
You don't want to stay?
My senior is held up in another court.
Yes. Condone the delay, usual orders, heard both sides. The, in view of the averments in the application for condonation of the delay of 15 days in filing the appeal shall stand condoned. List on the reopening date.
Please. Because we have already filed execution and tomorrow is the date.
Go ahead.
Please.
List it immediately after. Yes. Nothing is going to happen to the executing court also. Yes.
The appeal itself is not made for this reason. The company of the appellant is not in existence. It has been discarded. They cannot maintain the appeal itself.
There is.
Under section 250 of Companies Act.
Just a moment, just a moment.
This is a suit filed for specific performance. In the first instance, it was filed before the trial court, the civil court. Again, it was transferred to the commercial court. The commercial court, after conducting the case, after adducing of evidence, hearing the matter on merits, has dismissed the suit for specific performance, against which the appeal is filed.
Is there a finding that the appellant is no longer in existence?
Yes, It's an admitted fact. The document is also placed on record.
With kind leave, permission of the government. My lords, please, an appeal is pending before the concerned NCLT. My lords, so far as ours concerned. And with regard to the very maintainability of the suit before the Honorable Commercial Court is also in person, my lord, in this matter.
We'll consider this immediately.
Now,
after-
at this stage, how can they say, see, the moment that the matter was transferred from civil court, they would have challenged that order. That order they have not challenged. Before the commercial court also, they did not challenge. Now,
aspect,
how
my
can
lord.
they challenge in the appellate stage?
The judgment of the Honorable Supreme Court is subsequent to transfer of the
No,
matter
no,
by the
no, no.
civil court to the commercial court.
Lord-
Not relying upon
Lord-
the same.
After holidays. There is no.
The undertaking given by us,
Undertaking.
it shall not be continued. my lord.
Not to alienate only is there, my lord. And that order was operating
For
all along.
20 years, I'm
2007,
suffering.
my lord.
My land is being vested.
Immediately after holidays. Immediately after holidays, we'll hear it
The
on.
date may be fixed so
Yes.
that
That
14th or
undertaking may
15th,
be continued.
14th,
14th.
14th,
Much undertaking may kindly be continued.
till then. Yes.
I filed application before the trial court, my lord, with regard to refer the matter for the purpose of arbitration. But that application was dismissed by the trial court. I came before your lordship with regard to the,
There's a delay of 13 days.
yes, my lord.
Yes.
May kindly be
Notice-
condoned. May
No.
kindly be condoned. The application is, my lord,
This is not gone.
question is, my lord, is
This-
that the trial court is making hectic efforts to dispose of the matter, my lord. Till next date of hearing, my lord, with regard to,
Please take out notice, counsel. Yes. Pass over. Pass over. Yes.
Please, madam. If my lords will have the impugned order, my lords, starts at page 55 of my paper book, my lords,
Section 9,
section 9, my lords.
25.
And the order is extract, my lords, the order is at 57. Has my lord got that?
What was the interim measure that you had sought for?
No, I had not sought. They had sought
Yes.
the interim measure.
Yes.
Please, my lords, that's what, my lords, I am much obliged to my lord. If my lords will see in the same paper book, the prayer first.
Yes.
I am obliged. my lords. The prayers are at page 84.
Yes.
Has my lords got that? 84. The prayers, may I read it, my lord?
Just a moment, please.
Yes.
Please just read. 81.
I think it's 81. This is
section 9.
page numbering different.
You're talking about the affidavit, no?
84 and all, yeah, affidavit. I think so. So referring to 81.
Prayers are here.
Page numbering.
Okay. Okay. No, I'm so sorry.
That's also.
Yeah.
Prior incident on 3/3/24.
Please, my lord.
What is the amount due according to you?
The amount due is 6 crores.
48 lakhs.
58 lakhs, yes.
That is acknowledged according to you on
3/4/24.
424.
That is what they say.
Hmm.
I am disputing.
Understood. We're just looking at what the claim is.
Please.
Yes. What was the value of the insurance coverage?
4
Then-
crores, my lord,
4
as per their appeal memo.
Depository
No, my
insurance
lords.
claim amount under policy number so and so
Total policy.
before this court in interest bearing account. Direct to secure the amount of 6 crore 58 lakh 56,000 by depositing. Directing to disclose statement of assets, etc. Yes.
Please, my lords.
Hmm.
I'm much obliged, my lords. I've seen the prayer. My lords, first prayer itself is against respondent number 2, insurance company. My lords, second prayer is against me, who would be the party to the arbitration. Third is C is also against me. D is also against me for the stocks. But A, my lords, is against a third party who would not be even a party in the arbitration. Plus,
Is it required
yes,
My lord,
under
there are-
section 9?
yes, my lords, I have a judgment of Kerala High Court itself. My lords, I'll
What does
show,
it say?
please, my lord. If my lords want, I'll show it. Do you have a copy? No, no.
The soft copy. Do you have a hard copy?
I have.
That's all right. We'll manage.
My lords, I have passed on a compilation of judgments. But before judgments, if my lords will allow me to formulate my arguments, if my lords will permit. My lords, my learned friend is right. Says that on 15, the objections, my lords, for objections and hearing, my lords.
That is
But
all that has happened.
please, my
No.
lords,
How are you aggrieved as of now?
I am aggrieved, my lords, because this kind of order without any reasoning, without any observation against me, who is the party, who would be the party to the arbitration and claim is against me. However, the relief is granted against a third party and not only as a temporary injunction, my lords, by way of attachment. This is in a form of attachment, my lords, that something which is due to me
Yes.
and it is not even a garnishi order, my lords.
such other interim measure of protection as may appear to the court to be just and convenient.
Please, my lords, but
Mm.
if my lords will see the character of the order, my lords, I'm sure, my lords, the legislatures would have intended, but at the same time, my lords, if they are in 38.5 in CPC and 39, they are difference. But therefore, if in section 9, my lords, the court passes an order in the form of a garnishi order, because in effect, it is an attachment. Then, my lords, we have to revert to 38.5 also.
Attention, preservation, inspection.
No, you want to say something, then I'll say it.
Requesting, I'm asking if you're done, then I'll make.
No, I'm not done. I'm still, I'm not even,
Willing to offer security for the entire amount?
I'm so sorry.
Are you willing to offer security or some kind of assurance for the entire amount?
Milos, she knows, her client knows that there are stocks in the factory. There are stocks left over in the factory, which were saved from the fire, Milos. That stock, in any case, Milos, I have on merits, I have other grounds that those stocks they had to return back. That is more valuable. Here in the claim.
Those are not things we can consider at this stage in these proceedings. The question is only with regard to an interim measure of protection which has been granted.
Yes, my lords. So therefore is two things, my lords. If my lords, I'm a bit slow, my lords. So I need time to, my lords, go one by one.
This is why we have passed it over to hear you.
Yes, I'm much obliged, my lords. Therefore, my lords, the one thing, my lords, which has to be seen that, my lords, whether one that I have one, my lords, asked that what is the value of the claim? The value of the my lords, policy is 4 crores. We have filed a claim for 1 crore 78 lakhs. The claim is still is in the process of assessment, and they have a long assessment process and all that. So the claim has still not been crystallized. Whether I'll get 178 or 150, my lords, I don't know. Even they don't know.
Whatever you get should not be immediately released to you. Is the only.
But question is, my lords, the question is, first it has to come to me. Whatever I get, not to the, my lords, respondent number 2. Because the moment I get, they can move the arbitrator. Arbitrator will decide it independently. But a third party who doesn't have anything to do with the arbitration can be called upon to say that no, you won't, you first assess, then don't release. Whereas if my lords will know, because I don't know about this, but in insurance claims, the release is only to the claimant. So the stage has been jumped, my lords. Now straight away to the third party, my lords, judgment. If my lord will see from the compilation, if my lords will see, page number 30, my lords.
Just a moment. What is the order granted? Issue ex parte ad interim order of temporary injunction directing the respondent number 2 to deposit insurance claim proceeds for the insurance claim made by so-and-so under policy in a secure interest-bearing account before this court as prayed in IA within next date of hearing. This TI order will be operative only till the next date of hearing. Issue ex parte interim order. Notice on IA, main petition, applicant shall comply with provisions.
There is not.
Then what happens?
My lords,
Yes.
then my lords, on the next date of hearing, my lords, on 12/9, my lords, the page at 60, my lords, I'm sorry. Yes, 60, my lords. May I read it? Sri GP advocate has filed wakalat for respondent number 1 and praised time to file objection to main petition. Call on for objections to main petition and steps to respond number 2 by 15:10. My lords, and then
Number 2 has entered appearance?
Not yet, my lord. The RPD had not returned to court.
can we wait till it is listed to 1510 for that court?
Yes.
And if the respondent comes and enters appearance and states as you do, then probably the interim order can be modified to that effect as to how it is to be. Yes, to say that it has to be deposited in court. Probably the release to you can be injuncted.
May I submit?
Hmm.
There are two practical difficulties in this. Milos know with the insurance corporations and all, Milos giving a time that by next date, Milos, the whole assessment process has to be done. The inspection and all the inspection.
Correct.
Milos,
Correct.
hastening the entire process, Milos, will lead to, because they will then hasten the entire thing. In that process, my claim might be prejudiced. I have also an apprehension. Second, my lords, on the principles of law, my lords, I do not find, my lords, I may be wrong, I do not find any reasoning worth to give this kind of injunction, my lords, which is a pre-requirement, even by my lord's judgment. My lords have said, my lords, I have my lord's judgment. My lords have said that in an appeal against grant of interim injunction, my lords will be slow. In exceptional cases, only my lords will interfere. Now, if while exceptional cases, my lords will interfere, then even in exceptional cases, the ex parte interim order has to be granted.
Our only concern is it not for R2 to agitate these contentions with regard to their inability to.
Milos, I know
Is listed on 15th.
Milos, may I suggest something subject to my instructions? Huh? Okay.
The enter appearance in the.
May I?
Probably because of lack of time.
May I suggest something, Milos? If Milos will give me liberty and a direction to the commercial court to dispose of I will file my objections, Milos, to dispose of my objections on the same day, on 15th.
My lord, we will require time to consider their objections.
The R2 has to come on record.
Milos, the whole entire pleadings will take, Milos, they have appointed the arbitrator.
Not the, the R2 has to come on record. They have to be given some breathing time to place
Just
their.
3 weeks.
My lord, subject to R2 coming on record, even if they file their objections, we'll at least need to consider those objections, my lord.
Milos, R2 may
They
not
may
come
ask
or
you short
come.
date in court. That is okay. We will cooperate on that front. But to
Then-
say you hear us on the same day and dispose it without instructions from our
3
client is
weeks.
unreasonable, my lord.
Milos, 3 weeks, I'm asking you take instructions. Milos, because then this will go on. Arbitrator, they say that they have invoked arbitration. Milos, then let us get on with the arbitration.
Then the question is, can be decided in a section 17.
Yes, I'm much obliged.
We are okay to cooperate with that, my lord. It's just that R2 has to come on record. We see they are not present even before this honorable court, despite being a party to this appeal.
Why would they be?
They've been made a party, my lord.
They
The
haven't made
appellate
a
has made them a
party, but
party.
Because
they've
you made.
only been put on notice. They will probably appear at the next date of hearing before the commercial court.
Very well,
To
my lord.
anticipate an appeal and come here, what would be their interest?
Which is precisely our point, my lord. In the time where they should have filed objections there, they had sufficient time. There was more than a month that has passed between the date of hearing in commercial court. They appear there, they say we want time to file objections. And then they move this court.
Milos, I don't know what objection to this. I'm saying 3 weeks, it should be disposed of. And also in the meanwhile, respondent number 2 can go ahead with the processing of the claim.
My lord, if that
That's it.
prejudice the rights of respondent to, I have nobody to speak for them, my
How
lord.
can-
I'm only instructed for respondent number
What
1.
rights? Right is for hearing. There would be a hearing.
There could
What
arise
else?
a situation, my lord, where respondent number 2 is not on record. In which event, without hearing them, an IA that has been passed against them and not the appellant will have to be disposed of.
We will say that they can file their objections. They can file their objections, it will be considered in the appropriate orders. The time limit, fixing of a time limit for a commercial court to decide, there is a time limit provided by the law. We will say that on 15th, if you file your objections, those objections will be taken note of, and without undue delay, the orders will be passed.
Within 3 weeks? Milords, if,
The-
because this
the
is just
week-
an add-in
Week distance
objection.
may be a problem.
Because then this will prolong, Milords.
Then we'll list it after vacation. We'll hear you after vacation. In the meanwhile, please file your objections before the commercial court as well.
That's why I said, there is no point, because I have been, Milords, very,
The learned
Milords.
counsel for the appellant submits that the orders have been passed by the commercial court extending the ex parte injunction granted without specifying any reasons whatsoever. Full stop. The learned counsel appearing for the respondent, on the other hand, contends that the matter stands posted for return of notice to R2 to 15/10/2024, and it is open to the appellants also to submit their objections and to have the matter adjudicated. Having considered the contentions advanced, we are of the opinion that it is for the commercial court to consider the objections and to pass appropriate orders in accordance with law. The appeal is therefore disposed of with liberty to the appellant to file objections before the commercial court and to press for vacating of the orders, to press for vacation of or modification of the orders,
Very well.
which will be considered in accordance with law without undue delay.
without undue delay, Milords, and not.
Without delay.
Without delay and not waiting for respondent number 2 beyond 2 dates. Beyond 2, that is CPC, Milords.
That has to be, let the government, why do
Because
we assume that it will be?
Because in my, whatever limited experience I have seen, Milords.
Yes.
Much obliged, Milords, grateful.
Without delay. Yes.
Hope to see you, Milords, in my court, Milords, someday. Obliged.
I see some passo, senior counsel is,
Also,
senior counsel held up in quota number 1.
just a moment, what is item 35? Item 35 is Bangalore University.
Please, my lord. The appointment has been, single judge, my lord, is directed to appoint has been made on or before 6 months from the date of receipt of this order, my lord. An order dated 27/20/22.
List immediately after holidays.
Uh,
Can be listed immediately thereafter.
Is any date, my lord?
16, 15, 16. Can we take a B group? Over? Passed over is over? Yes.
Appearing for
What
the
is it
appellant.
that you wanted to?
Please, ma'am. Lord, the factual matrix of the case is the SLO has passed an award in 2011, my lord.
Just a moment. Yes,
Please, ma'am.
2011.
2011, the specific date.
No, never mind the date. It is in 2011.
2011, my lord. Subsequently, application under section 3G5 of the National Highways Act was moved before arbitrator, wherein the enhancement was done from 1,80,000 per cent to 2,10,000 per cent. The reasoning provided by the arbitrator was that the land was converted subsequently, my lord. However, then arbitration suit under 34 was preferred against that particular award, wherein the Honorable Court was pleased to set aside the arbitral award and remand back the petition before the arbitrator.
Whether the conversion was at the time of the notification or not. would have
No.
been the question.
Please, my lord.
Hmm.
Now, in that regard, my lord, subsequently, again, for the second time, the learned arbitrator confirmed the order passed by the predecessor, wherein further enhancing the amount to 2,18,400%, my lord. And in both the arbitral awards, the provisions or the benefits under RFCT LARR Act was also being made applicable to this particular compensation. Now, the contentions raised before the arbitrator and the Honorable Trial Court was the conversion order was dated in 2010, my lord. However, the 3A notification under NH Act was dated 18/12/2019. 18/12/2009. Sorry, my lord. Apology. 18/12/2009, my lord.
Conversion in 2010 will make no difference.
Please, my lord. That was the contention raised by the NHA appellants here.
How was it answered?
My lord, there was no particular answered detailed explanation to that effect, my lord. The only explanation that has been provided is the fact that there is a conversion order in 2010. That is the only reason for the enhancement which has been provided, my lord. If your lordship may kindly.
The date of the conversion order is not disputed by anybody.
It has been mentioned in the arbitral award, my lord. And even in the arbitration petition which was preferred.
Just a moment. 3A notification is on
18/12/2009, my lord.
Notification published in Gazette of India, so and so, on 2/3/2011. Final notification is on
Final notification is in 2010, my lord. 14/12/2010. The 3A notification is in 2009. Now, it is a settled position of law that the nature of land is to be considered as on the date of the notification under section 3A, my lord. Now, my lord, if your lordship.
Where is the order? I mean,
Please, my lord. Ink page.
conversion order?
Conversion order, my lord. If your lordship can come
Does it refer to?
Ink page 33, the running page 10 of the judgment, annexure A, my lord. Ink page 33, my lord. Para 12, my lord. This is the order passed by the trial court in the 2022, my lord. If I may permit. While going through the reasons assigned, while answering point number 2, the learned arbitrator has reasoned that the respondent number 2 had awarded the compensation in respect of land measuring 192 square meters and 81 square meters in survey number so and so, so and so. However, the special LAO had not taken into consideration the conversion of land for residential purpose, and the applicant has produced the conversion order dated 6/12/2010 for having converted 54 cents in so and so and 6 cents in so and so for residential purpose. The respondent number has failed to consider these facts before determining the compensation. Now, these factors were considered, my lord. And the fact that why it has been rejected is the only reason is that the 3A notification is passed in 2009 and the conversion order is dated 2010. And one more aspect which was ordered by the learned arbitrator was the benefits under the RFCT LARR. Now, in that regard, my lord, the RFCT LARR Act was made applicable to the acquisitions under NH Act in 2015. Now, the question with respect to the award was passed in 2011 and such award passed was also disbursed in 2012, my lord.
Amount disbursed in 2012.
12, please, my lord. As on 23/1/2012, I mentioned this in my appeal memo, my lord. So, aggrieved by these orders, we have preferred this particular appeal at hand.
Therefore, your contention is that you are not liable to deposit anything.
No, my lord, that is not the contention. If I may seek your lordship's attention to section 3G6 of National Highways Act. My lord.
Yes.
Subject to the provisions of this Act, the provisions of the Arbitration and Conciliation Act 1996 shall apply to every arbitration under this Act. My lord, the important part is the initial statement, which is the subject to the provisions of this Act. So, by virtue of this section, subsection, the provisions of the Arbitration and Conciliation Act is made applicable to acquisitions under NH Act only to the subject, the provisions which are contrary to NH Act is not made applicable. My lord, one more in this regard, subsequent to 2015 amendment,
amendment to the section 36 was brought under 34 as well, my lord. That is, if a stay application is filed under 34 as well, then earlier, as per the earlier provision, the stay was immediately given accordingly, my lord. However, subsequently, a separate application under a stay was made up, additionally required for the purpose of stay, my lord.
That's a settled position.
Please. 36(3), my lord. Upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may subject to such conditions as it may deem grant stay of the operation of such award for the reasons to be recorded in writing, provided the court shall, while considering the application for stay, the case for payment of money, have due regard to the provisions or grant of stay of money decree under the provisions of the Code of Civil Procedure. However, my lord, subsequently, there was an amendment also brought to the manner of depositing rules in the National Highways Act, my lord. The National Highways manner of depositing rules, 2019, my lord. And these rules are framed by virtue of the powers conferred under section 2 of the Act, my lord. If I may read the rule 3, my lord, the relevant rule is 3B, my lord, at page 77 of the writ, where the amount determined by the arbitrator under subsection 7 of section 3G of the Act is in excess of the amount determined by the competent authority. The excess amount, together with the interest, if any, awarded by the arbitrator within 30 days of the communication of the arbitrator's award, unless such award has been further challenged by either of the aggrieved parties, is what it says.
Just a moment.
Please.
Manner of making requisite funds available to the competent authority shall be as follows. Subject to provisions of the Act, etc. So and so. The Bank of India shall entitle the competent authority to withdraw the money from such account as per requirements without any further reference to the land acquiring agency for the disbursement to the landowners or person interested therein as follows. Amount determined under section 3G of the Act within 15 days of the raising of the demand, where the amount determined by the arbitrator under subsection 7 of 3G is in excess of the amount determined by the competent authority, excess amount, together with interest, if any, awarded by the arbitrator, within 30 days of the communication of the arbitrator's award, unless such award has been further challenged.
Please, my lord. Now
Therefore, your contention is when it is further challenged.
Please, my lord.
Then this
appellants at the NHA as the executing agency is not liable to deposit such further amount as determined. The excess amount which here in the even in the factual matrix, my lord, whatever the amount was determined by the SLAO has already been deposited with them. However, subsequently this enhancement award, the difference award preferred by the as ordered by the arbitrator, is not required to be deposited. My lord, in this regard, the similar issue was raised very recently before the Honorable High Court of Karnataka, Dharwad bench, my lord, wherein the division bench has held this. Okay. Now this issue was never raised before any other bench or any other honorable courts. Lord, the relevant paragraph is at page 12, my lord. 12 of the judgment. If I may. Lastly, the impugned judgment does not adhere to 2019 rules that have been promulgated by the central government under section 9 of the 1956 Act. Rule 3.1, which learned panel counsel had in support of his case pressed into service, reads as under. The manner of making the requisite funds available to the competent authority shall be as follows. Subject to the provisions of the Act, the executing agency authorized by the central government in this behalf shall open and maintain an account with one or more scheduled banks for remittance of the amount for land across the country, with arrangements for the access to such account by the competent authority for specific jurisdiction as per authorization of limit shall be by the executing agency. The executing agency shall, on the demand raised by the competent authority before announcement of the award, issue requisite authorization limit as per the competent authority for withdrawal of the amount from such account as per requirements from time to time for disbursement to the landowners or persons interested therein through an electronic banking mechanism as per Exchange Reserve Bank of India regulations, and the said authorization limits evolving in nature shall entitle the competent authority to withdraw money from such account as per requirements without any further reference to the land acquiring agency for disbursement to the landowners or persons interested therein as follows. The amount determined under section 3G of the Act within 15 days of the raising of the demand by the competent authority, and where the amount determined by the arbitrator under subsection 7 of 3G of the act is in excess of the amount determined by the competent authority, the excess amount together with interest, if any, awarded by the arbitrator within 30 days of the communication of the arbitrator's award, unless such award has been further challenged by either of the aggrieved parties. This provision of the rule arguably indicates the course of depositing the compensation amount in a particular eventuality. The panel counsel is right in indicating that subsection 6 of section 3G of 1956 Act makes applicability of the 1996 Act subject to the provisions of the former. This intent emerges because of the expression subject to the provisions of this Act employed in subsection 6, which internalizes the 1996 Act. Therefore, this provision could not have been ignored while deciding the writ petitions in as much as appeals in MFAs and writ petitions and pending post section 34 orders. In the above circumstances, both the appeal succeed and impugn judgment made in therein is cited not. Yes, please.
We understand the context.
Please, Manoj.
But does that mean that in a commercial appeal which is filed before this court,
Please, Manoj.
it is not open to this court to impose a condition?
Please,
This is normally, in normal circumstances, this is how you have to make your deposit.
Please.
Does that as a matter of fact mean that this court, when considering an appeal from an enhancement,
Please.
cannot direct the deposit?
The section 36(3) and the subsequent under interim applications for stay filed under Arbitration and Conciliation Act, subsequent to the amendment, says that it needs to be considered when there is a money involved as per the provisions of the Code of Civil Procedure. Now, subsequent to this amendment, the 2019 amendment was only brought into that particular reason because, my lord, there is again no security for that amount which has been deposited with the court, because again, there can be an application by the even by the respondent for seeking for the withdrawal of that amount as well, my lord. If the tomorrow
Can be, but
please, ma'am.
two things. The provisions of the Arbitration Act are made applicable subject to the provisions of the National
National.
Highways Act,
Please, ma'am.
not the rules made there.
Now, in that regard, this particular question was raised by the Honorable Court of the Jharkhand bench as well, my lord. Now, there was a judgment also produced. I'm apologies, I don't have that particular judgment with me, my lord, which it has been held by the apex court, stating that when the rules are framed by the powers by the virtue of the power conferred under the Act, such rules made applicable shall form part of that particular legislation and the Act. This has been held by the apex court, which was produced before the division bench of the Karnataka High Court. I shall produce it before your lordship, my lord.
Even in such case, does it tie the hands of a court exercising jurisdiction in appeal?
Please, ma'am.
Say that this shall be the condition for the grant of a stay.
My lord, the reason is, again, the 2019 amendment has been brought only subsequent to 2016 amendment, 2015 amendment, my lord. The reason being
Ever
the public.
be the amendments.
Please, ma'am.
We find.
Here,
Mm.
119, there was a rules regarding that. 1990 rules is there.
Mm.
In lieu of that rules, within 7 days from the date of award, they have to deposit their money.
No, which is why they say that the 2019 rules has been made to do away with that requirement. But
There is no bar.
no,
to the
even,
quantity.
exactly, that is the question.
Yes, ma'am.
Would that amount to a bar?
There is no. bar.
Your manner of deposit rules?
Please, ma'am.
Of the
Can-
rules also, there is no bar.
Absolutely. Can that be a bar on this court insisting in an appropriate case that the entire amount should be deposited?
My lord, in that regard, I shall again make good with the questions or the issues raised by the Honorable Court. In the meantime, my lord, my humble submission is a stay of the operation of the arbitral award and the impugned judgment may be passed, my lord, along with the condition of delay. Please, please, my lord, that is the humble submission. And initially at this position, my humble submission is an unconditional stay of the operation of the arbitral award and the impugned judgment may be passed, subject to the respondent having the liberty seeking for the modification of the order.
As a matter of fact, for an unconditional stay of the award,
Please, my lord.
you must first convince us that
Please,
we
please.
don't have a
Please.
that it is difficult to accept this proposition. Of course, subject to
Please.
your, I mean, we are always open to being persuaded otherwise. But
Please.
as of now,
Please.
this is a manner for you to make the deposit.
Please. Please.
Will that, as a matter of fact, take away the right of the appeal court to say that it is under these circumstances that the stay of execution shall be granted is a
Please.
question.
Please, I shall make good with the issues raised by this Honorable Court.
In the meanwhile, as a matter of fact, is execution filed?
No, my lord, as of now, it has not been filed. But, my lord, there is always a fear of the execution petition against this particular arbitral awards, my lord.
We'll say that it is admitted. We are considering the question of conditional stay as well and list it immediately after holidays.
Please, my lord.
Yes, issue notice to the, which you are taking notice for?
R2, my lords.
Issue notice to the first respondent. Issue emergent notice to the first respondent. List immediately after service is complete. The question with regard to grant of unconditional stay of execution will be considered at the next date of posting.
Please.
Please make available all the.
Please.
Normally, the list will be between the appellant and R1. On this question of law, I may be permitted to assist a lot.
First, the first respondent shall also be. Second respondent shall also be heard on the question of law.
My lord, a date may be fixed, my lord.
Yes. After 21st, any day after.
Grateful.
It was fixed on 16th, but you have senior. 17 or 18.
17 or 18 are not working days for us. There is a little difficulty for us. Yes, listed on some other day, 22nd, 29th.
I represent the
Just-
appellant. Last time there is a settlement proposal, my lord. Settlement
Yes.
negotiation was failed. And we are ready to contest the matter, my lord.
Okay.
Apart from that, one submission, my lord.
Oh.
On the last date of hearing, we have deposited 25 lakhs, my lord.
Hmm.
And the respondent has made a submission to withdraw the same.
Hmm.
Accordingly, we have given the consent to withdraw the same, my lord.
Hmm.
But the observation of the court, my lord,
Hmm.
we are not seriously disputing the principal amount. And the question is only with regard to the interest payable to
Not
the
correct.
respondent.
It was what was submitted the other day. That is
But
not correct.
That is not correct. That portion may be modified, my lord. And apart from that, my lord, one condition may be imposed. If I survives, the respondent has directed to deposit the entire amount along with the accrued interest, my lord. If he survives, he has always liberty to withdraw the same. That is my submission, my lord.
We had
Now he's withdrawing
specifically
his-
asked this. Yes.
Now he's withdrawing his admission that he doesn't dispute the principal amount. He's going to contest both.
But my appeal memorandum is also says, in my appeal memorandum,
It was only a submission made by the council.
Yes, yes.
It is not supported by any
I'm willing to
other
contest.
meeting. Heard both sides. It is submitted by the learned counsel for the appellant that the entire principal amount now stands deposited. And the respondents were permitted to withdraw the amount so deposited. However, it is submitted that the submission made that there is no serious dispute as regards the principal amount was an incorrect submission, which was erroneously made at the time of hearing by the council in question, and that the said submission may not bind the appellant. Full stop. In the above view of the matter, the submission made today that the contentions with regard to the entire amounts due and payable may be considered in the appeal is accepted. The release of the amounts in deposit to the respondent will be subject to result of the appeal. Subject to result of the appeal.
Yeah, but I'll be allowed to withdraw it now.
You can withdraw it subject to result of the appeal.
Yes, yes.
And if as a matter of fact, he succeeds in the appeal, then probably you will have to refund the
Yes,
amount.
yes, yes.
Lordship,
List
interim order may
immediately
be, interim order may be extended and call for the record, teaser, call for the record, chairman.
Yes, call for records, list on, etc., etc.
Interim order may be extended, ma'am.
Yes.
Much.
My lords, serial number 47, my lords. I'm appearing for the appellant. My lords, may I request for a pass over, my lords, in this case?
47.
Please, my lords.
7. Seeking for. Yes, it has not been called counsel.
My apologies, my lords.
Yes.
This matter, my lord, state was directed to verify if there are any vacancies. We communicated to the department, we not got back instructions.
Immediately after holidays.
My lords, may I request for a pass over? My lords, the respondents have been taking time. It's almost been a year ever since the matter had.
This is item 46.
Yes, I'm sorry. My
Yes.
apologies.
47 also, my lord, I do not have instructions. My colleague appears in this matter.
Please speak, switch on the mic and speak into the mic.
Serial number 47, my lord, I'm seeking for time after vacation. My colleague is not keeping well, my lord.
My
For
lord,
that reason, we have not
Oh, you
received
can make your
instructions.
my lords, I
Yes,
have
yes.
been instructed to take a pass over by my senior, my lords. She is on a
What is the matter
My
about?
lords, the petitioner has been charged. My lords, he is a clerk who was working with the Department of Mines and Geology. I have challenged the case at order, my lords, before your lordship.
We'll have
My
it
lord.
immediately after holidays, council.
My lords,
There is
a
no-
date may be fixed, my lords, in that case. May I
Yes,
request?
there is no time to hear it today.
My
Yes.
lords, may I request that a date be fixed, my lords?
Yes, date will be fixed.
Much obliged.
This I'm ready.
Ready.
Petitioner.
Yes, what is the matter?
Matter pertains to, my lord, selection of forest watcher, my lord, in the D group.
What watcher?
Forest watcher,
Forest watcher.
please, my lord.
Mike.
Yes.
The selection was, my lord, made by the authorities, my lord, in all the heads, my lord. At the time of original verification of the document, my lord, the petitioner's SSLC marks got on misplaced, my lord. Immediately, within the 3 to 4 days, my lord, he has obtained the second copy by the board, my lord. It was produced before the authorities, my lord. But the authorities, my lord, they rejected, they have not considered the mass card, my lord, produced by the petitioner herein, my lord. Then, my lord, the final selection list, in this final selection list, my lord, the third respondent was selected, my lord. But recent, as per the instruction, my lord, his candidature also rejected by the authorities, my lord. As per the recent on 7/6/2024, my lord. Therefore, my lord, the said post is still vacant till today, my lord.
That is not the question.
Please, my lord.
What was the provision in the notification with regard to production of documents?
Please, my lord. The SSLC mass card, my lord. The petitioner obtained the original, as per the annexure A1, my lord, it is the earlier mass card, my lord.
It is a requisite
Qualification,
qualification?
Yes.
Qualification. It is a curable defects, my lord, as per the Supreme Court judgment, my lord. And then, my lord, kindly see the mass card, my lord. Annexure A1 is the earlier mass card, my lord. It is produced, my lord, along with at the time of submitting the application, online application, my lord. Annexure A1. Subsequently, my lord, 3/2 document verification, my lord, on 1/3/2024, my lord. On that day, my lord, it was misplaced, my lord. Immediately, my lord, he has obtained, my lord, on 4/3/2024 itself, my lord. As per annexure A11, my lord, kindly see the annexure A11, my lord, page number 94, my lord. Second copy obtained by the authorities, my lord. Kindly see the page number 94, my lord, annexure A11. Page number 94, my lord, annexure A11. Bottom, my lord, date of entry, my lord, 4/3/2024, my lord. Annexure A11, my lord, page number 1994. Right side, my lord, top of the second copy, they have mentioned, put the seal, my lord. Bottom, my lord, mention the date, my lord, 4/3/2024, my lord. On 5/3/2024, my lord, the provisional selection list was made, my lord. They have filed the petitioner has filed the objection also. along with this Moscard, my lord. On 6/3/2024, my lord, the annexure A14 was made, my lord, by the department, my lord, without considering our candidature, my lord, selected the lower Moscard percentage, my lord. He has obtained 51%, 51.4, my lord. The petitioner obtained the percentage, my lord, 64, my lord. Therefore, my lord, kindly,
Which is the judgment that you are relying on?
please, my lord, I have narrated in the grounds also, my lord. I have produced, my lord. Ram Kumar Girjio versus Delhi Subordinate Service Selections, my lord. But post is still vacant, my lord. The selected candidate also is not rejected their claim.
That is not with regard to any essential qualification. That
Yes.
is with regard to caste certificate,
Please, my lord, I can understand, my lord.
caste and tribe certificate.
Well, I can understand, my lord.
This was also doubted and referred.
But here, my lord, in our matter also, my lord, this is correct, sir. What your lordship says that, my lord, is a caste. But mass card regarding our mass card is concerned, my lord, it is also curable defects, my lord.
It be a curable defect. That is your basic qualification. You did
Is
not.
SSLC mass card, my lord.
Correct.
Yes.
You did not have the.
I have, my lord.
At the time of verification.
I have at the time of filing the application, online application, I have, my lord, and uploaded the mass card. But at the time of verification, my lord, 3 days they have conducted the, my lord, physical endowment test as well as the other tests, my lord. All the tests, my lord, I have passed all the tests, my lord. At the time of document verification only, my lord, immediately I lodged the complaint and obtained the second copy also, my lord. Before provisional selection list, my lord, I have produced that document also.
Yes.
My lord, at page number 96, my lord, there is one list which is already issued, wherein respondent number 3's name is at the set category of GMPH, my lord, where he is selected. Now, my lord, the petitioner is making a submission that this particular candidate has now not been selected and the post is still lying vacant. That is a document which I have not taken instructions on.
No, that is not the question at all.
The question is that, my lord, he has not produced this SSLC marks card at the time of verification, my lord.
And it is
And
not.
that was the mandate, and it is very much, the notification only prescribes the basic qualification as SSLC, my lord. That was very much mandatory for him to have produced it, my lord. And he lodges a complaint. He appears before the selection committee on 1/3/24. Complaint is lodged by him on 2/3/24. It is his case that on that date, he has lost it, my lord. That is why it was disbelieved by the KAT, stating that it could not have been considered and he ought to have produced it.
Can be direct a consideration by you. We cannot say that the qualification, the primary qualification documents need not be produced at the time of verification. That is not the position.
Yes, ma'am.
There would have been several, and this is not a reason for, and it is not as if it is an admitted caste status that is being sought by producing it later. You don't think it can be, but if as a matter of fact, the post is vacant, He's also, it is physically handicapped,
My lord,
Please.
leprosy
Category?
cured, leprosy cured.
Prosecute.
64% marks he has.
Yes, my lord.
If as a matter of fact, it is not, it is lying vacant, whether you can do something, you can look into it. We cannot as a legal proposition lay down that
Correct.
it can be done.
Yes.
Here is it can be considered on the merits of his request. It appears that he had the marks card. You don't have a contention that it was not the one that, I mean, that there was any error in his marks.
I understand.
It appears that
May I take instructions from the department if the post is vacant and if they can consider, then I shall request the department if a representation ought to be given by the petitioner and be considered.
Please.
I'll take instructions on the
give
next
that
day.
representation also
Please.
in the meanwhile.
Please.
We list it after holidays.
Please.
In the meanwhile, let them see whether it can be done.
Please.
Because it is a genuine document, my lord, which was lost as a document which is.
Correct. It could have been true. As a matter of fact, that it was lost in transit when he was on the bus is what he says.
And now he
See,
says,
when he reaches there that he
and
realizes.
if it is still vacant and if it could be considered, I shall make an attempt. my lord.
Date.
The 20th, the week, beginning on 28th, they are saying. Please give your representation and produce it. Please,
Date.
please submit a representation and produce it.
Please.
Writing out all these facts.
Please.
Then we can then we can continue. Shall we?
ಸರ್ ಅದೆಲ್ಲ ಪೇಮೆಂಟ್ ಆಗಿದೆಯಂತಲ್ಲ ಸರ್? ಏನ್ ಹೇಳಿ?
Please, please, please.
We are not accepting anything now, Mr. Vish. Today it's for dictating. We are dictating and pronouncing the judgment. No. Sorry, it cannot be taken now. We provided you opportunity earlier.
No, reserved for order, they don't take it. So I said, I just brought it, I said, I'll give it in the court. Kindly see, the matter is connected to the order itself, just some addition.
Let's take it.
Yes.
Learned, the party in person, Mr. Vish, files a memo. Same is placed on record. Full stop.
order sheet, just take down the order. Having gone through the records by ourselves to see whether some relief could be granted, we do not find any error apparent on the face of record, or for that matter, any sufficient reason to show any indulgence by way of review of the judgment dated 26 November 2019, passed in writ appeal 3956 of 19. Petition is devoid of merits. No reason is made out by the petitioner to review the judgment dated 26 November 2019. We do not find any error apparent on the face of the record. Accordingly, we pass the following order. Review petition is dismissed. In view of dismissal of this review petition, pending applications do not survive for consideration. Same pales into insignificance. This one.
We are of the opinion that the finding of the learned single judge that the long delay of 17 years remains unexplained is completely legal and valid. We also notice that the judgment in the connected writ petition having become final, this appeal in one of the connected writ petition cannot be considered by us favorably. In the facts of the incident case, the question whether the act would be applicable would be irrelevant, since the undue delay defeats the rights even in case the act is found to be applicable. We have said that whether the act is applicable itself is open to question. That question does not arise because the delay defeats. We are also of the opinion that the question of punishment requires reconsideration. The said relief has already been granted by the tribunal. All further contentions have been considered by the tribunal. The petition fails and is accordingly dismissed. Reconsideration has already been ordered by the tribunal on the question of punishment.
Writ appeal number 883 of 2022 is allowed. Order dated 21st June 2022 passed by the learned single judge in writ petition 11179 of 2020 set aside. In your finding given in writ appeal number 883 of 2022, writ appeal number 593 of 2024, of which the appellant is not party to the proceedings in writ appeal number 883 of 2022, does not survive consideration and same is disposed of. Pending IS, if any, stand disposed of.
Great.
Lord, in this batch of writ petition, Lord, the matter was heard at great length, but could not be completed because the reply was pending. So thereafter, by a special order, then it has been listed
So
before.
let us list this after vacations so that we'll start. Yes.
Require some time because quite a few of them are approved. And I think on the last occasion, your lordships had said that they'll have to first cross the threshold bar of 2 orders passed by the Honorable Division Bench of this Honorable Court, my lord, where they had asked the BD and the state to consider virtually confirming the order of the learned single judge. If they are in a different thing, then probably. Yes, after vacation.
Matter already squarely covered by the Supreme Court judgment, your lordship, this matter.
After vacation, we'll hear this order.
Please.
Yes.
Yes. List after vacations, give a convenient date.
Date may be.
Yes.
Any date may be fixed, my lord, after vacation.
Can we have this in the first week of November?
This is a special bench, your lordship, that is.
Not on Monday, on any other day. 5th is not a Monday. No? 5th of November.
Great.
Appearing on behalf of the appellant, my lords. Please, my lords.
Week's time. Please comply with the office objections if any.
Please, my lords.
Memo for retirement. Memo for retirement can be accepted. Is there anybody representing? List it on some other day. R10, third time, week's time.
Please, outright. Please.
Yes, English translations only the relevant documents. All other office objections shall be
My lord, I
complied.
pray for 2 weeks time, my lord. I pray for 2 weeks time, my lord.
2 weeks time
Please.
to comply. Again, 2 weeks time. 2 weeks, 2 weeks.
But for the respondent.
Filed a memo, my lord.
What is
I
this?
filed an application for recalling, my lord, IA-1 of 2024.
Hmm.
My lord, by order dated 19/8/2024, my lord, respondents 5, 7, 8 and 9 were deleted. My lord, it was not noticed on that date when it was deleted, my lord. Hence, I'm seeking for recalling because they are necessary parties. They're GPA holders of the previous owners of the land, my lord. They are represented before the special deputy commissioner. Also, they were parties. The other side filed a memo seeking for deletion of these respondents. And an order was passed on that memo stating that they are deleted from the.
Lord,
Hence,
they are my predecessors in title, and this fact is admitted by them even in the affidavit
my lord,
supporting the.
if they are on record, it will be of no harm to the respondents, my lord.
Again,
I'm
my lord, I will
requesting that
point out-
that order be recalled, they be restored back to file.
I will,
Appeal is yours.
Please, my lord.
Yes.
my lords, these individuals are my predecessors in title. They have no remaining connection or interest with this matter. This fact is admitted by them even in their affidavit supporting my application. What has happened is, my lord, I filed an application, my lord, requesting that they may be deleted. Of course, it is their appeal. In the last order, my lord, what has been printed, my lord, is that they are deleted at the risk of the appellant. I can concede, my lord, it should be at my risk because I have sought that. Your lordships may kindly make that observation. They don't need to be pulled into this, my lord. They have nothing to do with this. There is a reason for this.
You
My lord,
want them to be on.
State wants them to be on record.
Yes, heard the learned counsel for the appellant. It is submitted that accepting IA-1 of 2021.
24.
Respondent number. IA-1 of 2021.
For deletion, please.
Respondents number 5, 7, 8 and 9 had been deleted at the risk of the appellant. Though the learned counsel for the respondent submits that the deletion can be at the risk of the applicant, that is the respondent in the writ appeal. The learned government advocate submits that respondent number 5, 7, 8 and 9 are necessary parties to the appeal. The above view of the matter, the order dated 19/8/2024 and IA-1 of 2021 is recalled. Appellant shall take out notice to respondents 5, 7, 8 and 9 as well. List immediately after vacation, immediately after service of notice.
May I please request some date, my lord? The dispute is pending from the year 2005.
Give a date. November. Yes.
Great.
Appellant, my lords, regarding R2C, I will take paper publication. My lords. I will take paper publication.
Have you taken note?
No, my lords, I have to take.
Yes, 4 steps. Weeks time granted.
Achha.
2 weeks time as a matter of fact. Yes. Yes, weeks time. 2 weeks time granted. Are 8 to 10 held sufficient. Notice to R 8 to 10, which is returned unclaimed, is held sufficient.
My lord, memo for dismissal of writ appeal at serial number 2, my lord, is filed. My lord, I've already filed a legal representative's application on 2/9/2024, my lord, so far as all these respondents are concerned. My lord, second point, my lord, so far as respondent number 28 is concerned, my lord, I have filed a memo on that same date submitting that I have not got the details of the legal representatives of respondent number 28 and I'm seeking for 2 weeks' time, my lord. So far as the other respondents who have deceased, my lord, I have already filed applications, necessary applications. Those applications may kindly be put on record and called after vacation, my lord. Notice will have to go to.
Yes. Call for the applications said to have been filed.
It's already
Not-
filed on 2nd.
I'm told that all your applications are returned with objections. They have not been refiled.
My lord, I shall submit. On the last date, my lord, we had submitted.
Please verify.
No, my lord.
this.
May I
Yes.
submit, my lord?
List after holidays. Let's see.
My lord's memo,
Yes.
filed a memo for dismissal.
Memo may not be necessary, my lord, because
If the applications are as a matter of fact filed, let us see. Please see that those are
Please, ma'am.
properly filed. Yes.
Respond number 3 to 8, my lord. Please write the objection in Wakalat, respondent Wakalat, my lord. Respondent's name is correct, my lord, in Wakalat. The applicant not correct stated in appeals memo, my lord.
As per writ petition cast title, my lord. In page number 16, my lord. As per cast title, my lord, the same cast title as given in the writ appeal cast title. Therefore, my lord,
There is no mistake in the name.
there is no mistake in it.
Yes. Office objections are overruled. Yes, counsel's objections taken on record. Office objections are overruled for the time being. List after holidays.
Much obliged.
Amendment of cost title. I may be permitted to carry it right now.
Week's time. Let's see.
Time for the respondent in this case. He wants we have given him, please, we have shown him whatever is available. He wants certain shops. We have shown him whatever is available. Now, but he says, he's not satisfied. I'll just check with the authority, please, if there's anything better that he'll
What
meet
is
his.
the office objection?
Office objection last time is complied with everything. Statement objection not filed and the burden. I have stated.
Yes, list after holidays. Let's see.
Obliged.
Yes. 68. Two weeks time. Yes.
Use
Deposit.
deposit amount.
2 weeks time.
Right.
2 weeks. 2 weeks, 2 weeks.
Also, I'm waiting for the respondents. My lords, I'm filing this memo seeking change of classification, my lords, due to inadvertent that's been filed as a COM AP. But then it ideally has to be a WP, my lords, because the order what we're challenging, the IAs have come to be dismissed, which don't fall within the purview of Order 43. So,
Cannot be.
my lord, on the same cause of action, they have filed another commercial appeal. It's being heard in court hall number 4, my lord. It's not the same. This cause of action tagged along with that, my lord. The cause of action is different, my lord. The order that we're challenging now is dated 3/8/2023.
What is that order?
IA 12 and IA 13, my lords. IA 13 was dismissal of our section application under section 151 of CPC. And IA number 12 is the court allowing DAG application seeking to produce additional documents under order 11 of CPC. And as such, these don't fall within the purview of order 43, my lords.
My lord, they're challenging an order of the commercial code. So in that sense, it's a commercial appeal.
Proviso to section 13.
Any order of the commercial code, can it be?
They're challenging the order, and the previous order which they challenge is being heard in court on number 4 in commercial appeal 499 of 23.
This is a question of maintainability, counsel.
Please. Well, it's the
They
progress.
admit that it is not maintainable as a commercial appeal. Would be the end of it.
Maybe tagged with the. It's not a commercial appeal as such, Mal.
Yes.
Same may be put up before the concerned host or Mal.
The learned counsel for the appellant submits that the appeal has been preferred as a commercial appeal by inadvertence, and that the appeal is not maintainable as a commercial appeal under Section 13 of the Commercial Courts Act. The appeal is therefore dismissed as not maintainable. It shall be returned to the appellant for filing as a writ petition.
As a W, the same may be converted, Mal. It's a classification.
You have to take it back and
Yes, Mal. And put up
yes.
before the concerned.
yes, the appeal is disposed of for statistical purposes. Yes,
Grateful.
you can take it back.
Malot, if it may be permitted, Malot, why we just permit us to change the classification and if it may put up before the concerned host, Malot. Provisions.
Everything, your pleadings, your grounds, everything will have to be changed.
I'll have
Yes.
the next. Grateful. I'm appearing on behalf of the appellant in this, Your Lordship.
What is the office objection?
Your Lordship, one is with regard to payment of court fee has been paid. The second is with regard to the GPA, Your Lordship, the client is in Hyderabad, we received the GPA this morning, that will also be undertaken.
Yes.
Your Lordship, in the meanwhile, we have also sought an interim order, Your Lordship, if that may be
No,
considered. We filed an application, page number 76 of the
yes,
appeal, Your
comply
Lordship.
with the office objections, list the IEA.
If it may be heard, Your Lordship, because the reason why we're,
Not today, we're sorry. Yes,
please, please.
week's time,
Sorry. Kannada translation.
translation, usual orders. Yes, whatever is relevant,
Yes.
we
it's all
make it
there.
available at.
It's all there. My lord, what has happened is there was, my lord, an interim order, temporary injunction granted without dispensing with prior notice. No reasons assigned. In fact, my lord, this honorable court, my lord, has repeatedly held under order 39 rule 3, if my lord, reasons are not, the reasons, my lord, must specify and spell out. Otherwise, my lord, it's bad in law.
Can we have this tomorrow?
Please look at, my lord, page 27.
Yes, can we have this tomorrow?
As your lordship.
Please, keep this allowed. Listed tomorrow. Yes.
Okay, for the petitioner, my lord, there's a translation, my lord, which has not been filed. The only translation is, my lord, in the order, my lord, they've come.
Translation, usual orders.
Yes.
Whatever is relevant, please produce. Yes, list
Much
it after all. Two weeks' time.
For the respondent caveator, my lord.
Objection is regarding translation. That's
Only that.
only that. Let's matter relates to transfer. Let's the second objection.
Both of us have reported a duty in the
That's
respective-
exactly why I didn't get an interim order. I came before your lordship. Your lordship on the same day relegated me.
Pass over, clear it. Yes.
Let's if it's, I understand your lordship's board tomorrow, my lord. Today I understand. My request for tomorrow, my lord.
No, after vacation, my lord.
No, my lord.
For the reason-
I may have some
for the
objection
reason
to that.
that, my lord, both
Let's-
of us have.
Pass over. Yes.
My lord, I understand your lordship's board today. Can,
Yes,
may I please
18.
request for tomorrow, my lord?
Let's see. Yes.
Very well.
Final hearing matters, we'll have this after holidays.
Please.
Can we
My
go
lord.
back to 53? Yes.
My lords, in serial number 80.8, my lords, the final hearing matter, my lords, yes, my lords, I filed an application to bring the LRs on record. So that may be considered, my lords, in 80.8, my lords.
We'll have this immediately. On the next date, it can be considered, council.
Please, my lords,
Just
obliged.
taking that out will be a, yes.
Much
Shall we
obliged.
take up the 230 hearing matters?
That's in serial number 97, there's an interim order which has to be extended. Serial number 90.
Obliged.
We make one,
Yes.
101.
Yes.
Final hearing, no doubt, my lord said after
Okay.
petition. But can some date be given
In my respective submission, it is covered by the Honorable Supreme Court's judgment, my lord. Sometime in
Consider it on the
October,
next date. We'll consider that on the next date.
no, the problem which I am facing is a similar question is before a learned single judge. Learned single judge feels, my lord, that he is going to dismiss the same and says, you also go and file an appeal. That is my difficulty, my lord. That is posted on 19th or so, my lord. So
Before that.
earlier that day, any day, 14th, 15th, any date, my lord.
Yes.
My lord.
All these 101 onwards. Sir.
101 only, the whole batch.
What is 101?
101 is writ appeal 1071 of 2022.
It's a batch of matters.
That is where, under the Ancillary Act to the Land Acquisition Act, whether the award is to be passed under the new act is the question. KID Act, my lord, although its main object is industrial development, it has also provisions to acquire land
Yes.
for industrial development. Whether the land acquired under that is entitled to the benefit of the new act is the question.
Under the repealed act, after the act came to be repealed,
My lord said,
the award is not passed. Proceedings are pending. Whether the award can be passed under the new act or not. The learned single judge not found that a new act is to be made applicable.
my lord
When the proceedings are pending, there is an amendment to the KIDB Act. The provisions of the 2013 Act is made applicable. That's the position. Either under the BD Act or under the KIDB Act, the provision for passing an award is not there, except issuing a final notification. Till today, my lord, right from 1966, award was passed only by invoking the provisions of 89. That's the position. And in view of the Nagpur city improvement.
my lord said
that-
prior to 15th of October, 16th October, but saying November.
Possible, we can give
Yeah,
the listing, but
my
it
lord,
may not.
by installments, your lordship need not hear, my lord, we will.
Cannot be, yes, let's list it on some day when when it is possible to be taken up. May not be possible, that is the difficulty.
My lord, a small submission with the
Yes.
permission. Still number 86. Blood in those interim orders method.
Yes,
101.
yes.
My lord, in serial number 86.
101 ಅಲ್ಲಿ entry ಮಾಡಿರ್ತೀಯಾ?
In an order passed to daily orders on 23/9/2024.
ಒಂದು ನಿಮಿಷ
There was a
ಹೇಳ್ತೀನಿ
submission from my side as a respondent.
ಹೇಳ್ತೀನಿ
That salary there, for some people, salaries are not paid.
101
But
connected
it is shown as
80
made a submission. It is there in the order.
Last date, the respondent also had made a submission.
80 ಹೌದು ಹೌದು 80 81 82 83 no only 80 only 80
So that is
80
the reason.
to 80.9
It will continue in the report.
All the employees have received the payment. That is the sufficient.
ನಮ್ಮ ಕೆಲಸ ಮುಗಿತು
86, please list it tomorrow. We'll make the correction tomorrow.
I make a submission, Your Lordship.
Yes,
Serial number 102, Your Lordship, the final hearing. We have
yes,
submitted our written submissions,
yes.
but there is a office note stating that wakalat is not forthcoming. So we have rectified that particular office objection, my lords. So it may be moved from the list.
Any date when is declared in
List it after holidays.
Interim order may be extended.
next month ending.
102. 102, 102.
89, a date may be fixed. No, that's all.
Date-
All matters, dates will be fixed. Yes,
That's all.
Interim order may be extended.
yes.
Sorry for remind. 101. There is an interim order
In
earlier.
any cases where there are interim orders will stand extended till the next date of year. Yes.
I had made a request.
Your request will be, if the matter is not over today, your request will be specifically, we'll pass specific orders. Otherwise, if if the matter is being heard and taken, then let us, yes.
What on the previous occasion, my lord, short question, my lord, which was posed, was whether the government is not inclined regarding the regularization of these, or to make the fresh scheme in accordance with the orders of the learned civil judge. No, my lord, the stand of the government, my lord, is not to implement any fresh scheme. When the already pre-existing scheme is there. So in view of that, my lord, the government is of the opinion that no new scheme will be formed.
Yes, the question would be this, what is the nature of the scheme? What was the nature of the scheme which was?
Yes, ma'am. It was only, my lord, to give a financial succor, my lord, to unemployed youth in the villages, my lord. And here, my lord, since it is not a continuous employment, with this meter reading and collection of revenue is done only about 2 or 3 days in a month. The rest of the time they are free, my lord. That's the reason a scheme was made instead of any regular appointment. So a scheme was framed, and under the schemes, not the MOU was to be made between the persons who are engaged and the companies, not, and they will take it further. And every year, not those MOU would be renewed.
Is there a specific scheme which is put, which is in writing with regard to
There's
how they
nothing in specific except for the speech made on the floor in a budget scheme. It's a newspaper endorsement. That's nothing else.
There is no written scheme as such.
Except no written, except for the paper notification and the speech made on the floor of the house. There's nothing much, but based on that, the MOUs have been made and then they have been related by the companies. And now, my lord, it is between the companies and thing. And moreover, my lord, it's a memo.
Can I have
It is
volume?
regarding
please?
the latest,
Volume 2 of this.
regulation regarding Electricity Regulatory Commission regarding prepaid smart metering. 2024. From 2.7, prepaid and prepayment meter, smart meter at 2.10. So this is where the new technology is being adopted for the purpose of meter reading and also collection of revenue as far as is concerned. Now the implementation model here this stands at 3 stages. One is generation of electricity, then next is transmission of electricity, and then distribution of electricity. Distribution of electricity may not falls on the companies like Bescom and Escom. These companies will not know how to regulate themselves. Here, the option is given for the consumers to choose if they want such kind of a meter or not. But it is being implemented gradually overall. My lord. This is the new technology which is being adopted. Hence, my lord, at the GVP level, tomorrow there will be no job, no work in fact.
Yes.
And the cadre aspect of it, my lord, they were, meter reader cadre is higher than to a junior lineman. The entry point is not junior lineman, then it is lineman, then it is senior lineman. And senior lineman, another nomenclature to it is meter reader. No, not here, being GVPs, they cannot directly be taken in that category.
Yes, what exactly were the recommendations of the committee and how were they dealt with by the government? The committee?
Yes. One month.
Yes.
Not a 15-member high level committee was formed.
And what
And there
exactly?
also the recommendation is that they cannot be observed, or they cannot be
What
regularized.
exactly is the recommendation?
The recommendation is that they cannot be regularized.
Hmm.
That those copies I will secure.
Copies are produced.
Page 704.
Page 704. Nantra,
67.
idu illa nantra. Yeah, it was a lot of files are missing in the office.
Volume 3, it is there.
Yes, ma'am. Page 704. The following committee was formed in view of reviewing the demands of workers who are serving as rural electric representatives in various power supply companies located across the state as per government orders and so.
Yes.
The above named committee was instructed to verify the following points. Basis on recruitment of a rural electrical representatives, Gram Panchayat, judgment of the Supreme Court in Srimati Umadevi case and as applicable in the case with respect to the recruitment of rural electric representatives, other objects of the rural electric representatives appointment and facilities provided by the power supply companies to rural electric representatives, method of appointment of rural electric representatives, number of present vacant posts matching to the rural electric representatives. No, the next paragraph, 705, the bottom one plus 1. Basis of appointment of rural electric representatives. The Honorable Chief Minister of Karnataka had announced commencement of rural electric representatives recruitment program on dated 5/2/2004 during the 2004-5 budget speech. He had informed that this program aims at providing job opportunities to rural youth who involved in works like meter reading, bill collection and minor electric repair works, respective Gram Panchayat limits. The employees who will be appointed under this program will be paid remuneration from the fee that they collect. In order to supervise the power distribution, rural system, rural areas under the Rajiv Gandhi Rural Electrification Scheme, services of NGOs, user forums, cooperative societies or persons and panchayat institutions can be utilized as franchisees. The service of such franchisees can be utilized also for power management, feeder and transformer maintenance. Appointment procedure. The eligibility of company wise. All the power supply companies have appointed the rural electric representatives, GVPs, by giving newspaper advertisement based on the CM's budget speech. The scope of work of these representatives will be limited to particular panchayat limits. No, eligibility. But the appointment eligibilities, the second column, should be a resident of a particular Gram Panchayat limit. Rupees 250 the application. The overall interview would be conducted in case more than one candidate applies for the post to sign the agreement. Training will be provided. Then the age limit to bank guarantee. The age limit is also not 18 to 30 years. Then in HESCOM,
it is 18 to 40 years. ESCOM, my lord, 18 to 35 years. So maximum period they can serve, my lord, even according to his age, is up to 40 only. That is as far as ESCOM is concerned. So even if a person were appointed at 20, 25, no, my lord, already 20 years are elapsed. So they would have crossed the age limit also.
Age limit is for appointment.
Yes, ma'am. Appointment. I'm sorry, ma'am. I agree. I stand corrected, ma'am. I agree.
Yes.
If you notice the appointment eligibility mentioned above, the eligibility criteria stipulated is not uniform among all electricity supply companies, while a few ESCOM have stipulated SSLC as the minimum educational qualification. A few of the ESCOMs have not stipulated the minimum qualification. Hence, there is no uniformity in qualification. Reservation rules. Gulbarga Power Supply Company has followed the reservation rule only in the first appointment process. Accordingly, they have mentioned that the applicable fee of ₹100 and age limit is between 18 and 40 and provided exemption from giving bank guarantee. But the remaining ESCOM have not followed the reservation rules. Company-wise wages mentioned in the time of recruitment on 10% remuneration per month based on the amount collected during the month. SESCOM and MESCOM at ₹2,000 wages per month with an additional 8% commission if they exceed the stipulated fee amount collected. And HESCOM not at so and so. JESCOM not 2,000 salary per month on the basis of line collection, service duration. None of the ESCOM have mentioned the duration of service, but it is mentioned that the service duration will be 1 year in case of an agreement as the micro feeder franchising. The agreement should be renewed every year. Micro franchises which do not function as per the agreement made with the ESCOM will be cancelled. Responsibilities and aims of rural electric representatives. One is meter reading, distributing bills, fee collection, receiving complaints, providing guidance to people who seek new connection. Details of companies wise rural electric representatives. Number of vacant posts, number of representatives appointed, and number of them working.
Yes.
7. Honorable Supreme Court judgment given in Srimati Uma Devi's case and applicability. The Finance Department has given the following opinion with respect to Srimati Uma Devi's case. The contract basis employment is an exceptional method of recruitment. It is not a proper recruitment process. Every vacancy should be filled up by following stipulated appointment procedures as per the stipulated group and appointment rules. By following this, it will be possible to recruit good quality and eligible candidates and also follow the government reservation rules. Contract basis appointments are like backdoor entry. As per the Honorable Supreme Court judgment in Uma Devi's case, it is fine. The Honorable Supreme Court in his judgment, in the case also ordered not to reopen the case that has already been settled earlier and not consider such illegal recruitment process in the future. The judgment is not limited only to the government department, but also applicable to NGOs, corporations and boards. Hence, the Public Reform Department is herewith informed that there is no provision to regularize, make such services permanent in such cases.
Yes, 709 appears to be,
709,
709 appears to be the consideration.
yes, ma'am, that's the
Considering
consideration.
all the points.
Yes, ma'am. To point number 9. Then, my lord, considering all the points mentioned above, and after discussion, the committee has given the following opinion. The appointment of rural electric representatives has been made clear that announcement made by the Honorable Chief Minister on so and so budget, there was no approval for reservation of posts for rural electric representatives in electric supply companies at the time of recruitment. But the job responsibilities of these rural electric representatives
can be compared with that of meter readers who are working as electricity supply companies. The appointment of rural electric representatives has been made with an objective of providing job opportunities to local youth. That was the objective.
Yes.
In order to monitor and maintain the supply of power in rural areas under Rajiv Gandhi Rural Electrification Scheme, there is a regulation to utilize the rural youth as feeder franchises. The rural electric representatives who were appointed in the year 2006 are being used as an alternative for feeder franchises. Presently, nobody is being recognized as rural electric representatives. All the persons who are recruited or appointed in the name of are identified as micro feeder franchises, and they have signed an annual contract with the respective electric companies. The recruitment process cannot be compared with the Srimati Umadevi's as or that of the daily wage workers recruitment process. The rural electric representatives have applied on their own wish and have agreed to the appointment by signing the agreement voluntarily. The rural electric representative appointed, the GVP, is not a permanent process held as per rules. There are no sanctioned posts for them in the electric supply companies. The following differences have been noticed in the agreement made between the rural electric representatives and electricity supply companies. Payment of remuneration, bank guarantee amount, imposition of fine, payment of allowance. But these rural elected representatives do not exhibit any interest about discussing or modifying any of the points they have signed in the agreement. They just claim that they have been given their consent to continue the agreement format that is in force. The rural electric representatives contract study subcommittee held a meeting on dated 8/7/2014 and recommended the following modifications based on the BESCOM contract format. And in that, what is important is B, contract duration, Article 2. The tenure of this contract is limited only for 1 year. Legal limit. The rural electric representatives who have worked as agents of the power supply companies, and they cannot be considered as employees of ESCOM at any cost. Well, on next page, Article 4.2. That is regarding the deposit. They should deposit the amount collected into BESCOM office or post office on the very same day. This is one of the duties for them. And point number 4 on the next page, 712. It is not possible to regularize the microfeeder franchisee jobs and compensate it with the vacant meter reader posts.
Please read all the recommendations.
Yes, ma'am. Sorry. Yeah. From additional responsibilities.
No, recommendations of the proposed committee.
Below. Yes, ma'am. The works that are being done by the rural electric representatives are major works of the electricity supply companies. As all the works being done by rural electric representatives are uniform in all the electric supply companies, equal remuneration can be provided. As the rural electric representatives are carrying out the major responsibilities of the company, apart from uniform remuneration, medical allowance, new pension scheme, and action can be provided on humanitarian basis. Next point, this is important aspect. It is not possible to recognize the microfeeder franchisee jobs and compensate it with the vacant meter reader posts in the electricity supply companies because they are working on yearly contract basis with electricity companies, electricity supply companies, and hence are completely serving as franchisees. This is the stand. Already finished reading.
Yes. Then what was the finding by the, how was it treated by the government? How was this
Yes, ma'am.
recommendation?
Yes, ma'am.
It was not accepted, even that part of the recommendation, which was.
The last bit of the recommendation, no, it is accepted.
Only that was accepted, the
Yes,
others were not considered. So how was it, as a matter of fact, does it say the reason why it is not accepted?
I mean, under these reasons, what it says it is not acceptable. No. Moreover, on following Uma Devi's case. Brought page number 731,
Hmm.
government proceedings,
Hmm.
translation, document number.
Yes.
Here, my lord, Honorable Chief Minister on the budget speech made on so and so had announced the recruitment of rural elected representatives. It was announced that an attempt being made to create job opportunities and to educate rural youth who will be engaged in various works like meter reading, bill amount collection, and other minor electric repair works by GVP, respective Gram Panchayat limits. It was also decided to pay remuneration to them out of the amount collected, so and so. Right, I'll skip the next paragraph, not going into the next one. Based on the 2004-5 budget speech made by the Honorable Chief Minister, so and so. Electric supply companies in the state released advertisements in print media regarding appointment of rural electric representatives limited to their respective Gram Panchayat limit. They appointed the candidates for job for the post. But these vacancies are not granted posts. The appointment procedure has not followed as per the appointment rules and regulations followed by the proper power supply companies. At that time, the reservation rules have not been followed. Moreover, their work contract is only 1 year. It's only 1 year and is being renewed every year. Meanwhile, the rural electric representatives working in various electric supply companies have demanded the government to regularize their jobs and increase the remuneration and provide other facilities to them. In order to consider these demands, the committee comprising 13 members were formed. Based on the report submitted by this committee, several changes have been included in the MOU, like payment of 12,000 rupees, 12,000 uniform, remuneration and 2,000 incentive. Apart from this, a sum of rupees 2 lakhs compensation shall be provided in case the worker dies while on duty, or additional rupees 5,000 to meet medical expenses. Accordingly, all these allowances and facilities are being provided to them. In the meanwhile, the GVP is working under WESCOM, under MOU, have appealed before the Honorable High Court requesting to regularize their jobs by writ petition number so and so read above. In this case, the Honorable High Court held a trial on dated so and so in the presence of 3 higher officials of Energy Department and heard the interim orders mentioned in serial number 2 above and fixed the trial date as on so and so. The details are as follows. Having considered the views from both the stakeholders, this court makes the following order. The government shall, in consultation with all the concerned departments, if necessary with the management of KPCL and ESCOM, shall take a policy decision as per the recommendations of the 13-member committee constituted by it concerning the grievances of Gram Vijay Pratinidhis of fresh within an outer limit of 8 weeks in accordance with the respondent government shall file fortnightly the progress of decision-making process by an affidavit of.
I'll see if with the same.
An affidavit of an official not below the rank of Principal Secretary, Department of Energy, furnishing all material particulars. And it is made clear that the period prescribed in para number 1 above should not be extended by showing strong reasons. Because this matters not so much. Presently, as per the directions given in the interim orders dated 2019, with a view of considering Gram Vijay Proceedings demands, the government is instructed to consult different departments and take action within 8 weeks. It abruptly ended. But then the emphasis not the para 10 of the judgment states as follows. The states have made acts, rules.
Your Lordship. Document doesn't have the translation of 2 pages. I have informed the appellant's counsel. This sure, if after this para abruptly ended. If
Yes.
we see the Kannada order, Kannada version, there it's 2 pages is missing. I have informed the counsel to the appellants.
Not legible. This is Kannada. But here, pardon me, my lord. My lord, here what is those 2 pages which are missing is regarding those factors not where the decisions have been taken by the high level committee meeting in consultation not with the companies. Those aspects not for the end the recommendations which have been which they have consulted and considered that is one that is missing. Actually, my lord, it is in Kannada. We need to have a translated copy, my lord, for my lord to appreciate this in so I think they would file a translated copy also to take it further.
Anyway, the final decision by the government is there is the context of the explanation given in the proposal now, so there is working on MOU basis or while filling up of posts of meter readers that are vacant through direct recruitment. There is no provision to provide facilities like relaxation, education, qualification, providing weightage based on their service tenure while they apply for the posts of meter readers. These orders are issued. The committee had not specifically recommended those measures, had they?
Yes.
The committee had only said that their major works and they're carrying out major responsibilities, there should be uniform remuneration, medical allowance, new pension scheme, and accident benefits
Yes.
can be provided on humanitarian terms.
Not,
Committee had also said that it is not possible to regularize
Regularize.
the franchisee jobs
Yes.
or to compensate it with meter reader posts. So
Exactly.
where is the consideration of these other claims? The the recommendations with regard to uniform remuneration, medical allowance, pension scheme, and accident benefits. That was a recommendation.
Yes, Munad,
The
that's not.
recommendation was not that they should be regularized.
Is-
or
Not,
that
not,
they
not
should
on
be-
regularization, on the other aspects.
Or that they should be absorbed in the, as meter readers by giving them benefits. That was not the recommendation.
That is not the
The
recommendation.
recommendation was that they
Only
should
to
be
provide uniform.
among themselves.
Yes,
There should be uniform remuneration.
Yes.
The new pension scheme, they make part of the contribution.
yes.
Therefore, the
Well, that is not implemented.
consideration was whether the new pension scheme could be given, medical benefits could be provided, and accident benefits could be provided. These were the only 4 recommendations.
They are only recommendations.
Has that been considered in your,
No, Munad, not considered.
now the learned single judge says,
Page 484. Volume 3. 2.
volume 2 is the judgment.
Volume 2. Munad.
Your contention that it is for the employer to decide on the question of regularization has essentially been accepted by the court. Court only says that the pedantic manner in which it has been, the recommendations
Yes.
have been dealt with by the government.
Yes.
Court says that there is some force in the contention of the respondents that a writ court ordinarily does not itself direct regularization or payment of wages on the principle of equal pay for equal work. The power of the court is coextensive with the requirement of doing justice in accordance with law. However, these are matters which essentially pertain to the domain of the employer and the government of the day. A host of factors enter the decision-making process. Court is ill-suited for undertaking such an arduous exercise, etc. The impugned orders which rejected the recommendations of the committee are being infected with legal infirmities are liable to be invalidated, facilitating consideration of the matter afresh. Therefore, all that you are saying now are matters that you can possibly take up in response. But what were the recommendations and whether they are liable to be accepted or not should gain the attention. That is all the court says.
Yes.
Court does not direct consideration. Court does not even direct equal work for equal pay.
True.
Because the court says whether the work is equal is something which the court is ill-equipped to consider. It is for the government and the employer to consider those issues. But
True.
to say that even a consideration is not warranted
Yes.
in the light of the recommendations may not be correct. The directions issued are also writ of certiorari issues squashing the impugned government orders, whereby the GVP's claim for absorption, regularization, and for grant of wages in regular pay scales have been rejected. Writ of mandamus issues to the first respondent to frame a fair scheme for considering the claim of GVPs for regularization, absorption, etc., keeping in view the high-level committee recommendations. Identify the post whose job chart substantially matches with the work being done by GVPs. Yes.
Yes, ma'am. To pay them with minimum wages in a minimum pay scale admissible to such posts, having in mind recommendations of high-level committee and observation in Kollayar's case. But here, my lord, the question is, when they are not being regularized at all,
The high-level
the question
committee-
of implementing the
He had not
other
recommended.
recommendations doesn't arise.
High-level, the other recommendations do arise. The high-level committee had not recommended regularization.
No,
The high-level committee had also not directed equal pay for equal work.
proven,
All that was, whether the pay was equal, the high-level committee actually did not consider.
did not consider at all.
All that was stated is, all these persons are appointed under the same scheme.
Yes, ma'am.
What you claim was was relatable, the scheme was relatable to the budget speech of
Budget speech of Chief
2004.
Minister. Yes, ma'am.
There is wide discrepancy in the pay and conditions of service
Yes.
among these people, the GVPs
Yes,
themselves.
yes,
That was what one aspect which was addressed.
true.
The second aspect was that they have continued in service for nearly 20 years now.
Yes,
And therefore, some kind of protections, including maybe the contributory pension scheme
yes,
and medical benefits. It is an admitted fact that even if it's a part-time engagement.
yes, yes,
Imagine the case of part-time sweepers or part-time servants in government departments.
yes,
They have some kind of protection.
true.
It is directed to be considered, and
Yes.
those recommendations apparently have not been considered at all.
True. Yes, ma'am. Here,
Even
ma'am,
if everything
even
that
though
has
the-
been
even-
argued
Yes, ma'am.
by the companies
Yeah,
on
it is,
Uma Devi and
yes,
the
ma'am.
other later judgments not being
It is- it is for,
in total.
no, for the
No.
companies, my lord, to implement that aspect.
Yes,
As far as the
so
recommendations are
we
concerned.
are not even going to that extent. We are saying that even if everything that they've argued is accepted
Yes,
on the basis of the other judgments, cannot really detract from Uma Devi.
true.
And the position propounded in Uma Devi is the correct position. And
Yes.
it cannot be diluted by two judge or division
true,
bench
madam.
judgments, even if that is totally accepted. Even so, the reconsideration is in order because the recommendations have not been considered by the government. Unless you can show us from the rest of the 2 pages that those recommendations have also been considered.
So the 2 pages, right, there's nothing. I'll take a minute. not there. No, my lord, it has not considered. Either the accident claims nor anything. Such recommendations have not been considered. The other 2 pages, my lord, as far as I go through this, this is only with regard to Uma Devi's case. The emphasis has been extracted here, my lord, and that has been taken into consideration by virtue of Uma Devi's case. It has been, that's the whole thing. So that's the sum and substance of these 2 pages.
Yes.
Yes.
What do you say, Senior Counsel?
Not another aspect, not in Uma Devi. Also, it is also said that the court should not interfere into a scheme. So that aspect.
Court does not propose to.
Yes, sir.
It is only whether you have considered properly, which is the question which is being addressed before the court.
Yes, I placed myself.
We don't propose to direct you to implement any scheme or to, but
Yes.
when there is such a number involved, it should be considered as all we are saying. There are recommendations. You yourself appoint a committee. No, you yourself appoint a 15-member committee, a high power committee,
Yes.
who give certain recommendations. And those recommendations are not even referred to in the order by which you consider them. Should not be how. Yes, anyway, we'll, subject of course to what the respondents have to say.
Milord, I was submitting the other day. Initially, Milord, the policy decision flows from the budget speech of the Chief Minister on the floor of the House.
Just one.
Please.
Can I- 499 is the budget speech, nobody.
Yes, ma'am.
That is a true translation.
Yes.
Yes.
That is an initial stage where we introduce this scheme in each panchayat initially, and it will be extended to the whole of Karnataka. This is a position.
Correct.
Meter reader, Grama Vidyut, billing, everything, it is there. Now, my lord, based on this, notifications were issued. My lord, I'm only trying to appeal to your lordship, my lord. There are 2 aspects of the matter which has to be dealt now. The learned single judge has clearly recorded finding. It is a clear case of a contract of service, not a contract for service. Now, based on the paper notification, applications were invited, committee has been constituted, applications were screened, thereafter, my lord, interviews were held, we have been sent for training, and after training, my lords, the work has been assigned to us as a meter reader. And I am just appealing to your lordships is, this is not a case where a meter reader, installation of a meter is regulated by a central act. I read to your lordship section 53, and the license holder, that is either BESCOM or HESCOM or whatever it may be, they will have to install the meter reader. Meter is regulated by section 55 of the Electricity Act. Not all that I am appealing to your lordships is the apex court has considered in a case where a license, my lord, survey license holders have been issued by the license, by the government. They were trapped under the PC Act. Then the question was whether they are the license holders issued by the government to survey the lands. The matter went to the Supreme Court. My Lord Justice Sikri has interpreted that license have been issued by the government. They are discharging the statutory duties. Therefore, they are functioning as a civil servant and the relationship would come. Now, my lord, all that, my lord, I am not apply the same principle here. But here, the very genesis on which you are licensed to supply the power is based on fixing the meter under section 55 of the Electricity Act. Then there is a one more provision stating that section 62 may take your lordships, my lord, the provisions of the Electricity Act.
Yes.
Section 55, my lords. Use etc. of meters.
Yes.
No licensee shall supply electricity after the expiry of the 2 years to the appointed date, except through installation of a correct meter in accordance with the regulations to be made in this behalf by the authority. Provided that the license may require the consumer to give him security for the price of a meter and enter into an agreement for hire thereof unless the consumer elects to purchase a meter. Now they wanted to introduce the smart meter, that is optional. Then, for proper accounting and auditing the generation, transmission and distribution or trading of electricity, the authority may direct the installation of meter by generating company or a licensee at such stages of generation, transmission or distribution or trading electricity, and such locations of generation, transmission, distribution or trading it may deem fit necessary. If a person makes a default in complying with the provisions contained in this section, regulation made in subsection 1, the appropriate commission may make such an order. Now, my lord, this is the statutory duty. May I take your lordships to section 62, my lords. Determination of tariff. The appropriate commission shall determine the tariff in accordance with the provisions of this Act for supply of the electricity by a generating company to a distribution license, provided that the appropriate commission may, in case of shortage of supply, your lordship may skip it off, transmission authority, wheeling of retail sale, everything is there. This is power to fix the price of the power. Why, my lord? So,
Regulatory commission.
yes.
Power is in the commission,
Yes,
not
ma'am.
in the licensing.
Now, kindly come to the section 50, my lord.
Yes.
The state commission shall specify an electricity supply code to provide for recovery of electricity charges, intervals for billing of electricity charges, disconnection of supply of the electricity for non-payment thereof, restoration of supply of electricity, measures for preventing tampering, distress or damage to electrical plant or electrical line or meter, entry of distribution, licensee or any person acting on his behalf for disconnecting supply and removing the meter, entry for replacing, altering or maintaining electric lines or electricity plants or meter and such other matter. Now, my lord, this is how the State Election Commission has framed the regulations in 2004, which I'll read to your lordship. A person, how the meter reader has to be worked out, what all the liabilities, what all the duties, how a billing has to take place, how disconnection has. My lord, I am only putting in a one nutshell. These are all statutory duties which we are discharged.
Chair, I don't think there is any objection to that.
Yes, my lord.
I don't think.
My
that's-
learned friend says I am only an agent. That's it. They
You are engaged on contract to carry out these functions.
No, my lord,
Nobody has.
I am not on contract. I will inform your lordship. I am only, my lord, laying a foundation to submit the argument advanced that I am only an independent contractor. There is no relations of employer and employee relationship. That is totally incorrect. The reason is, my lord, if there is an independent contract between the employer and employee, the matter stands on a different footing. Here is a case where the policy decision flows from the floor of the house. Then all companies issues a paper notification in terms of Article 14, 16 of the Constitution of India. The applications are invited. We have been screened, selected, trained, and appointments have been issued. Now, when we go to them, they take the agreement, impose all conditions which are unconscionable terms of the contract. I am so grateful to my learned friend by producing the agreement because he keeps the entire control of these employees with the electricity company, supply company. My lord, I am only appealing to your lordship. My lord, I have already produced, my lord, this regulations of 2004. My lord, before the learned single judge, volume 4.
It appears that within the next hour, this will not be over. We'll have to hear it on later dates as well.
My lord, this is a very important an issue where
We don't want to rush you. We are only saying that it does not appear that it will be over in the next 1 hour. If that is so, then making it fattered again would be another problem. So how do we, shall we list it after the holidays for a further hearing?
my lord, your lordship, since your lordship virtually heard of it's a public time.
Half has been heard.
Correct. Half your lordship. Your lordship may not have it on any Fridays so that we can.
And
My lord, my submission, my submission.
hear you and not, probably not just one.
My lord, my submission to your lordship should be, our case is all trappings of regular selection process have been followed by them, number one.
Except reservation.
Pardon, my lord.
Except reservation.
In one unit, reservation has been followed. Number two, at the time when we go for the employment, the duty report, they have obtained an agreement. Exactly in the similar case in 2021, the Apex Court said, when you invite an application and make the selection process, when I go for reporting for duty, you obtain an agreement. Those agreement is unconscionable term. It has to be treated as a regular appointment. This is how my Lord Justice, Chief Justice U.U. Lalit has interpreted and found and said, these are all the terms which are unconscionable. Therefore, they are the weaker section to the contract. Therefore, this has to be ignored, erased from the scene. So therefore, my lords, this is all the one aspect of the matter. I shall satisfy your lordship the finding of the learned single judge is a contract for service, of service, not a contract for service. Coming to the government appeal, my lord, there are totally 46 batch of cases. Now, my lord, the appeal has been filed only as against one petition. Now, my lord, in view of the, if there are, your lordships are aware of it, that the judgment delivered by the apex court, that if two suits are clubbed, a common judgment is delivered. In one, you file an appeal as against one, you don't file an appeal as against the other one, you are barred by the principle of res judicata. 66 Supreme Court 1332, where one appeal was dismissed for not filing a paper book. The Supreme Court has stated that one appeal has been dismissed for non-prosecution, would operate as a res judicata for others. Now, in the government appeal, there are totally 46 cases which have been clubbed together. Appeal has been filed only as against one. So therefore, they are bound by this principle of res judicata. My lord, it is only there is a total lack of empathy from both sides, from left side and the right side. I am appealing to your lordships, my lord. They apply the principles of Justice Krishna here in Usanbai case, where if any, even in a case of an intermediary contractor, if a services rendered by an employee reaches the services of an employer, then ignore these intermediary, all these things. That is one aspect of the matter. The second is the latest Supreme Court judgment on 22nd July 2024. And the last week there is a judgment, my lords Imakole along with Mehtaji, where a temporary employee, but discharging a regular work, were ordered to be paid full benefits like a permanent employee. That's the position, my lord. So now the finding by the committee is that we are discharging the duties of a meter reader.
Yes.
Meter reader. That's the position, my lord. I'm so sorry, my learned friend said monthly 2 days and 3 days. We start by 7, we'll come by 7 p.m. and 10 p.m.
Yes, we'll consider this on. Thirtieth of October will be okay.
Please.
30th. With regard to the IA in writ appeal 684, we are directing that they should be re-engaged.
Lord, I'll just give 1 or 2 dates only, my lord.
Yes.
That's all. I won't take
Yes.
more time.
Yes.
The relevant date. This writ appeal was admitted and an interim order was granted on 8/3/21. They were not continuing up to 27/3/23. When a show cause notice was issued and no reply, so on 29/4/23,
Just a moment, show cause notice was on?
27th March to 23, saying that you are not doing your work and you are not given guarantee. And 30 days time was given. They were called for a meeting. They didn't come. They didn't give guarantee and they didn't reply also. So 29/4/23, the order was passed to say we are not continuing your contract. Though, my lord, there was some discussion. Some officers said we should continue. Some said no. But finally, the decision-making authority said, no, we can't continue them. We can't renew the contract. This application is filed 1 year later, my lord, 18/4/24. So 1 year they've not worked. Now, my lord, last date, my lord.
We are not directing any payment of anything in the meanwhile, nothing, no back wages, nothing. We are only directing re-engagement in view of the fact that
The day they start
Fact was-
working, the day they start.
fact is that they have, as a matter of fact, given the.
But
bank
even now,
guarantee.
bank guarantee is not valid.
No, no, we have renewed it.
No,
They
please see.
they will renew it. If it is not valid, they will renew it.
Yes, madam.
My lord, 1 year later only, my lord, they file.
No, no, this year, January, they have terminated.
Just
Now
a
the
moment.
documents are separate,
need for that,
submissions
madam.
are wrong.
we are only directing re-engagement. And continuance subject to result of the writ appeal.
My lord, there have been some changes, my lord, in how we work also. So we really don't need those people today.
Yes, IA number 1 of 2024 and writ appeal 684 of 2020.
3,000 meters each
We have-
employee is working.
We have considered the contentions advanced. The IA is prayed seeking the following reliefs. Objections are also on record at the instance of the appellants herein. That is the supply company. Having considered the contentions advanced and perused the document placed on record. Especially on record, as also an order of the chief engineer dated 31/5/2021 and the letter dated 12/7/2023 of the executive engineer. That is a recommendation. 12/7/2023 of the executive engineer. We are of the opinion that the petitioners in this IA are entitled to the benefit of re-engagement
From 17/1/24 is the date.
in service since there does, in service in terms of the interim order, never mind, re-engagement in service. The executive engineer in the recommendation dated 12/7/2003, 12/7/2023 has specifically stated that the bank guarantee has been furnished by the MFFs concerned and had recommended their re-engagement. There'll be a.
That is expired, what my learned friend is.
We'll
it is
renew it.
submitted by the learned
They have to give letters for renewal.
senior counsel appearing for the appellant that the said bank guarantees would have expired by now. In the above view of the matter, there'll be a direction to the respondents in the IA to re-engage the petitioners and permit them to continue in service by accepting a valid bank guarantee
Much of it.
and subject to the rights of the employer to take individual action against them in case
Renewal,
there is
renewal.
any misconduct found on their.
Or failure to perform. So
Those
the contract
guarantees
talks
which are already
for certain
furnished, they have to
targets.
give us letters to renew it. They have to give letters.
No, we don't have to give a.
They have
letter.
to give letters in every other case they have given. a furnished copy.
Please provide,
They have to give renewal letters.
please provide relevant bank guarantees. Yes, don't stand on the technicalities of. Yes.
Much
Three
obliged.
steps shall be taken within a period of 3 weeks.
Love, 2 weeks.
Engage, 2 weeks to re-engage.
Lord, may I make another submission, Lord?
Yes,
In 53.3,
Hmm.
my lord, there is an interim order, my lord, in this case, we have been terminated, my lord, challenging which we filed the writ petition. There is a direction to reinstate us. My lord, for the past 4 years, my lord, we have been out of employment. There is an interim order, so I have filed an application seeking for vacating the interim order so that, my lord, at least we could be reinstated. My lord. For the past 4 years, we are out of employment. It's a stigmatic termination.
that will have to be,
My lord, in fact, I made a request
that
to.
we consider,
Have it.
We'll examine. Lord.
please. Yes, we list it on 30th.
Sir, I am told there is 1,000 posts of this GVP. They advertise it for outsource. Instead of outsource, under the Industrial Disputes Act, a person who puts in 2 per day is entitled for re-employment under Rule 66. They could have done that. Andhra Construction, my Lord Justice Krishna, has said, your re-employment in terms of Rule 66.
Appears to be a case for a consideration. Or everything else, how it is to be considered would be the question. We can-
Only submission, my lord, thought which came to my mind, my lord, when your lordships are posing question to the learned government advocate. This is a committee which was formed by the government itself. To what extent, my lord, will they actually be bound by it is one issue. But as your ladyship is rightly pointing out, my lord, if there is a report, they must
Consideration.
apply the mind.
It requires a consideration, and when admittedly they are in engagement, whatever, we won't say in service, even if it is a purely contractual engagement for 20 years, whether, because those persons who were appointed backdoor without any post being there, without even, in some cases, without even having qualifications, an act has been enacted for their benefit. There are persons who have been engaged after calling for applications by newspaper advertisements. Don't they at least require a consideration of their claim
Please.
for?
Please.
It was done with its holidays. It just has to come one day. Try and finish it.
My lords, if I may be permitted to mention a matter, we are the appellants, we filed a miscellaneous first appeal. The urgency is that the respondents have unilaterally appointed an arbitrator, and the arbitrator has passed an order, ex parte order, conditionally attaching the director's personal accounts and the company's bank accounts.
As against that, how will an appeal lie here?
My lords?
As against the order of the arbitrator,
Yes, my lord.
how will an appeal lie here?
My lords, which is why we are seeking, we filed the appeal on the basis that they have, the respondents have unilaterally initiated arbitration proceedings without even giving us sufficient notice as required under section 21 of
Even
the.
so, where do you go? It's not to this court. The court concerned would then be the. How would it be maintainable at all? Please look that up. Please, I don't think it would be maintainable here at all. What is the subject matter of your appeal? This order passed by the arbitrator?
Yes, my lords. My lords, it's not a final order. The order is from an application under section 17. It's not the final, it's not the award.
Section 17 order is appealable under 37? Section 17 order is appealable?
Please, my lords.
Where does it say? Granting or refusing to grant an interim measure under section 17. Yes.
My lords, if the matter may be had tomorrow, there's. My lords, you
Yes,
request the
that
matter may.
Yes.
My lords, you request the matter to be heard tomorrow. There's urgency in the matter, my lords. It's a personal accounts of the directors and they've financially been crippled. They're not even able to use their own bank accounts. Request the matter to be heard tomorrow, my lords.
Let us see.
Even at the end of the list, my lords, just request it to be listed.
Is the entire matter scanned? If it is not scanned, it may not happen.
My lords, we'll follow up with that. We just request it to be listed tomorrow.
Yes, let us see. Yes, let's. Are you really insisting on hearing the transfer matter at 4:30?
We wait up to after vacation, my lord, is my submission for the reason, my lord, that both of them we have joined our respective posts. I have been working since.
Where are you? Where have you joined?
He had completed his tenure. I was posted to his place last year.
Tell us where the places are.
Same building, same place.
We'll have it immediately.
I'm not, last year he completed his tenure. I went to his place. This year, my lord, he comes back to my place. They say, my lord, I'm not entitled to a tenure.
Both are in the same place.
Both are in the same place. He completes,
Different places, my lord,
No, my lord.
different
Therefore,
office.
therefore, it is not a case of extreme hardship or difficulty. We'll have it immediately afterwards.
My only difficulty is, my lord, at the stage of interim order, they said they have taken charge, my lord. My interim order was not considered. But I came before your lordship directed me to go back. Now, my lord, I have faced an order, final order. Now, my lord, virtually my interim order has never been considered.
Only a
Very well. I'm in your.
posting in another post.
The legal issue, of course.
It's legal issue being considered. Otherwise, in normal circumstances, the question does not arise for consideration at all. A transfer from one place to another. It is only because of the special nature of the jurisprudence here that we have to consider this at all. In any other high court, I can assure you, this would not have been touched specifically on such a situation. The day before the court closes for vacation.
Tribunal says I have no tenure at all. I am not entitled to the protection of guide.
Consider it. Immediately.
I request. Same stage achieved, if the office objection. Very good.
Yes, same stage.
Very good.
But I only took time to refer to a judgment. I found out that I just wanted to find out if it's still the law. But on the nature and scope of a B report. The main grievance of this state is that its right to assess the suitability of a candidate has been sort of constricted by the order passed by the tribunal. Because it is to consider only the final select list and not the B report. My only contention is there should not be any such restriction. We should be allowed to consider the B report also, because as per the decision of a division bench of this honorable court, my lord, B report is on a lesser footing as compared to even an acquittal. The lordship already knows that in Avtar Singh's case, the principle of honorable acquittal has been borrowed to apply even to a case where the appointing authority is assessing the suitability of a candidate.
Therefore, is it your case that in a case where there is, as a matter of fact, no crime pending, not even in an investigation, can you, by your, can the government by itself say that I'm not satisfied with the character and antecedents? Can you, is it possible?
They have to assess the B report is also my submission. They should be also given the liberty. The government as an appointing authority is not precluded to consider even the B report while assessing the suitability of a candidate is what I'm saying. Because I may just refer to this decision of the Honorable Supreme Court. At page 11 of my written submissions, I mentioned what is the issue arising for consideration. I just read the issue and then take your lordships to the relevant portion of the judgment. The substantive issue that arises for consideration in this case is whether the appointing authority is precluded from taking a decision on the suitability of a candidate selected for appointment to a civil post on account of B report under section 173 clause 2 of the CRPC coming to be filed in a criminal case registered against him. But the judgment is at page 17. J. Alexander versus State of Karnataka. It's 1995 SCC online. But in para 10, what was the contention of the petitioners is mentioned. In view of the courts in cases relied on by for the petitioner, that once a final report under section 173 has been sent, the police cannot touch the case again and cannot reopen the investigation. In the opinion of the Law Commission, in a narrow view, and places hindrance in the way of the investigating agency, which can be very unfair to the prosecution and for that matter, even for the accused. To obviate such a difficulty, section 173 CRPC was amended to enable the competent police officer to examine evidence collected further to report under section 173 clause 2 and send a further report to the magistrate. Thus, the object of section 173 clause 8 is clear, and it is not confined only to cases where cognizance is taken. Then, my lord, what is contemplated under section 173(4), well, I will not take much time in paragraph 11. I just want to point out that from the 7th line from the bottom, my lord, the provisions of law in question I just want to point out that a B report is on a lesser footing as compared to an acquittal. It says that
So what happens once it's accepted?
even this was a case when it is accepted. So even when it is accepted, it does not give finality to the matter is what is held. Because it can be reopened under 173 clause 8, provided further material is available. Now, all that I'm saying based on this judgment is that
The
it
question
should
is
be.
this, can it be left to an appointing authority to decide on separate facts in separate cases? But what would be the necessary standard of character and antecedents? Can you in a case say, there is no FIR, there is no crime,
Please.
there is nothing as against the person, but I don't like, there was a crime which has been referred. I don't like this person. Therefore, I think this is a case where the B report should not be considered. Should there not be something concrete for you to bank on to say that this person, this character and antecedents
Indeed,
are
madam.
not?
Indeed, my lord. For
Therefore,
that
can
reason.
you, as a matter of fact, say that in this case, the allegations are very serious. There is a B report. However, we'll wait and see whether anything further comes out. There is no further investigation as of now.
Indeed.
Nobody has a case. So can there be such a kind of a subjective power given to an appointing authority to decide in which case he'll accept the character and antecedents as being satisfactory, which he will not? What is the basic rule of service law at all? The basic rule is that whatever is applicable must be applicable across the board to everyone. That is the purpose of having rules.
Please.
And rules, we cannot make exemptions to rules for the simple reason that the rule should be applicable to everyone across the board. The person who is to be appointed and the person who appoints should know the rules and should apply them equally. Now, to say that in a case where there is, as of now,
No criminal case.
no criminal case at all, to say that there was a criminal, and that criminal case, the allegations in the criminal case were of very serious nature. And therefore, we will not accept the closure of the investigation. We will wait.
Yes.
And
Look.
we will not allow them to join duty in spite of this.
I understood the question, my lord. I understood the concern of the court also. And I just want to point out from the facts of this case only, just two facts, my lord. My lord, it is the duty and as well as the right of any employer, my lord, to consider the suitability of a candidate before appointment is made regarding the character and antecedents. My
Must
lord, in
be
this
on
case,
objective criteria.
indeed, my lord.
That is,
Indeed.
yes.
My lord, in this particular case, the appointing authority has never had an occasion to apply its mind. That is what I'm saying. At the time of passing of the order, my lord, from the time when the background verification was made, till the time the writ petition was filed, their character was under a cloud, because it was only after the filing of the writ petition that the B reports came to be filed. I've given all the dates, my lord. It was in October, writ petition was filed in September, and most of the B reports came to be accepted. Although the B reports were filed prior to the filing of the writ petition, they came to be accepted only after the filing of the writ petition. Now, there was a change circumstance. So under the change circumstance, the government should be given an opportunity to consider the case of the.
Do you have a case that there is anything else pending as against them? You have, as a matter of fact, conducted the investigation.
Indeed.
The verification has been conducted. Do you have a case that there is anything else as against them? If there is, of course, we are not saying.
Well, the question would be whether the government cannot apply its mind at all to the B report. In fact, from the contention of the petition, the respondents itself, my lord, one of the contentions is they have challenged the communication sent by the third respondent, Deputy Commissioner of Police, saying that because there is a case pending, there is a direction given to the appointing authority without the authority of law, because they are not, the Deputy Commissioner of Police is not the appointing authority. So he doesn't have the authority to dictate to the government that appointment order should not be issued. But my lord, on facts, my lord, there is no such direction. But be that as it may, the claim is, it is not the third respondent, Deputy Commissioner of Police, who has to give such a direction. It is the government that should apply its mind, being the appointing authority. So all I'm saying is, my lord, the tribunal restricts there has never been a consideration of the case of the petitioners. My lord, the liberty should be given to the government. My lord, I'll also point out two things, my lord. It may or may not be relevant, my lord. On facts, my lord, one of the facts is that an amount of 15 lakh rupees was transferred in the very order which is under challenge, the communication, it is mentioned that 15 lakh rupees was transferred from the father's account of the father of the candidate's account to that of the accused. And the charge sheet is quashed only on a technicality. When the tribunal passed its order, it was quashed only on a technicality insofar as the respondents are concerned. There were other accused persons who committed malpractice in the teacher's examination and those who supplied the answers. Against them, charge sheet is now issued.
Is it open either to the government or to the Director General of Police in his capacity as the appointing authority to consider those issues?
My lord, I'm
Whether
relying on a
there is-
decision, another decision, my lord, where
Whether the amount had actually been transferred, whether the amount was transferred for this purpose or.
my lord, it
Isn't
may be
the function of the investigating authority to investigate.
indeed, ma'am.
Therefore, once that comes to an end, can the government, we are not on the facts of the case, can the government or the appointing authority
The
go
government-
behind the findings or the reference or the B report
Indeed.
and say that
It may be wrong for the government to do that. I admit that, my lord, but all I'm saying is reserve the liberty of the government to consider the B report is all I'm saying, because
government cannot consider it
Yes.
for the purpose of verification of character and antecedents. How can we, as constitutional courts, permit that exercise?
my lord, in Avtar Singh's case, my lord, the Honorable Supreme Court draws a parallel between an assessment prior to appointment on the basis of the character and antecedents of the character of the candidate and disciplinary proceedings, my lord. In that, it says that the criminal proceedings and disciplinary proceedings can be held independent of each other. They are distinct and separate and have no bearing on each other, except in one case where it's an honorable acquittal based on same charges and the evidence being the same. My lord, if it were to be said that there cannot be any assessment at all in case where a B report is filed, it would mean that the criminal case would have a bearing, my lord. My lord, if disciplinary proceedings are similar to the assessment prior to appointment,
If I could. Yes, what is
my lord,
the?
I'm relying on
which
another
judgment
judgment,
you
my lord.
want to
I just want to, my lord, the relevant portion is actually 15. I will not go through it because I've extracted it.
16.
I'm 15, my lord. I've extracted it. My lord, I'm relying on the judgment at para 23 to say that a fresh representation has to be given in the light of the changed circumstance, because the government,
There's only paragraph 17 here. You're relying on your.
my lord, page 23 of page 23, my lord.
23 is the other judgment.
Vikram Singh judgment, yes.
Vikram.
I'm relying on this to say that liberty should be reserved to the government to consider the case of the suitability of the candidates, and a fresh direction should be given, which is at para 4.1.
Should consider whether that is warranted
Please.
in the facts.
Please.
Yes.
My note is that I just culled out the dates. And I just written a one-line reply to whatever my learned friend has argued. Just one point, Your Lordship. The question about assessment of a B report, according to my limited knowledge, that should have happened in a magistrate court, and that has actually happened in this. That is why there is a gap between the filing of the B report and the acceptance of the B report. Now that a government wing has accepted it, that is the police filing it and the prosecution not objecting the same, and everybody and the magistrate accepting it, the question of government again deciding on it for the second time does not arise. Another important aspect is what the government is trying to do is to give an absolute power to, it's reserving an absolute power to itself to decide on the character of a person.
Sorry, we are not on the facts of this case. If
My lord,
we
as
say that
appointing
there is-
authority, I'm saying they have not considered at all.
If there is, we say that this was the reason, if we say that there is a further power to consider, that will.
No, I'm not saying that, my lord. I'm only saying that the government should have the liberty, even when there is a B report, it should be allowed to consider the B report is all I'm saying.
That is going behind
Because
judgments of
government,
two courts,
as an
magistrate
appointing,
accepting the B report as well as the KSAT court. That is my
the
apprehension.
power of the appointing authority is
The Lordship in this.
not to be restricted is all I'm saying.
The way the government has defended this case speaks a lot, targeting one batch of petitioners who have come clean in the investigation which they themselves have conducted. And further now, Your Lordship, I would like to bring to Your Lordship's notice one important aspect. This entire
process has conducted in the year 2017. The respondents herein are nearing their age wherein they'll be barred from appointing. That is why they're just stretching it so that after that they get barred. Anyway, they won't be selected.
To say that come clean may not be correct, because it is held that only finality is given when an acquittal is happened. That I have judgment relied on that judgment of the on this division bench of the.
What do you say? It's selected.
Nothing, because in this case, the government would have challenged the B report. They're not happy with it, for one. Secondly, my lord, generally, when a cloud is there, it is not fair on the part of the government to appoint such candidates, and what kind of message we are going to give to the society, being a selecting authority, that much I can submit, my lord. And what sort of work we can expect, service we can expect. By keeping this in mind, I request my lordships to pass the order. That's all, my lord. Nothing in this case other than these two. One in the interest of the society, and other one the mistake committed by the government without challenging the B reports, if at all anything found in the B report.
Your lordship, the problem
Without
lies
doing
there.
so,
If there was a
it's not
challenge,
good for the
then I
government to
understand.
challenge before my lordships. But being a selecting authority,
Lord, all I'm saying is government has never applied its mind, has never had an opportunity to apply its mind. The circumstances changed only after the filing of the writ petition.
If it applies its mind to the B report now.
Lord, the tribunal, in my respectful submission, my lord, has taken over the responsibility of the government to assess the suitability by saying that B report should not be considered,
They are asking you.
by limiting the consideration only to.
Asking you. There is a verification of antecedents and character and antecedents to be carried out by. Now, there is a B report which has not been objected to.
Indeed.
Accepted. The matter is at end there. Now, if the government is given the power, what again can the government say? That the allegations are of a heinous nature. Therefore, we will not accept the acceptance of the B report.
Well, that opportunity should be given is all I'm saying.
Is it
As
open?
opportunity is given to an employee,
If it is given, what will the government do? What can the government do?
Lord, my respectful submission, it is only the government which can take a decision on that matter. Because
Your lordship, that
even
is what I submitted.
they
are
may-
driving
they
us
may
back
come to a
the court
conclusion.
Challenge that also. We'll consider.
please, grateful.
Very grateful.
Serial number 101, interim orders kindly vacant. Serial number 3 and 1. Madam.